hear, you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. I'm Judge Capper, and we're starting the court now. Before we start our review hearings, I'll go ahead and introduce some folks. We got people from Nationwide Children's Hospital in Columbus here today that are doing a research project. They've been there before, so if you want to stand up, I'll let you introduce yourselves. But they're doing a research project where they are trying to collect data all across the state. And if you want to participate in this, you can actually get paid for doing the work, and it's all confidential. I know they've been doing this for a while. They haven't told me anything. I don't know who participates, who doesn't. And the idea is not to collect your individual data that goes into a pool and to cut down on overdoses. That's to try to get data about that, what people's habits are, is my understanding. I'll let you speak, but that's the purpose, is a good effect to reduce the rate of overdoses in the state. So if you would go ahead and introduce yourself and tell a little more about it.
So I'm Natalie, this is my colleague Zara. We are researchers from Nationwide Children's Hospital up in Columbus, and we're currently recruiting for a study, again looking at different interventions that may work best at reducing overdoses, specifically among people involved with the courts. A few important things to note: it's voluntary, so you don't have to participate. Again, it's confidential, so any information you share with us won't be shared back to the court or anyone involved with your case. And then finally, it is paid. So today, for about like 25, 30 minutes of your time, you'll receive $25 on what's called a study claim card. It pretty much works the same as a Visa debit card. We load the money on there, and then you guys should be able to use it today. Your participation in the study also consists of taking other surveys, but after today, the rest of it is done remotely, either through text or email. So this is the only day that we would be in person. If you complete all the other surveys, you could earn up to like around $360 over the course of 2 years. Again, we're just looking at different ways, interventions that work best at reducing overdoses. So if anyone has any questions, or if you're interested in participating, we are in the probation office on the left. Thank you. Thank you.
Thank you very much. So if you're interested, after you finish court, or there's a law you don't think your case is going to be called for a while, you can go over and meet with them there in the probation office, which as you exit the courtroom would be to the west side of the building to your left as you're leaving. So the first thing we're going to do this morning are reviews, and that's for people who have had orders to comply with from the court, and this is a check to see how that's going. So if you're here for that, your name's going to be called. Come up to the table to the right, to your right, and stand there. I'll go over your file with you. If you don't get called and think you should have, you need to go check in with the clerk and see why your case wasn't called. And if you missed a hearing previously, it won't be called with reviews. It'll come back on later. So go check in with the clerk if your name isn't called. Call reviews.
David Abrams, Jason Collier, Aaron Cottrell, Russell Daniels, Donald Dickus, and Cameron Harris.
All right, David Abrams is here, and I do have a report from OVP Healthcare, and compliant with he's doing outpatient there, and he's compliant with his program there. He's done some community service since we last had a hearing. Can you make any payment on your fines today?
Yes, sir. Yes, sir.
Okay, how much are you going to pay?
40.
40, okay. All right, well, good work. Looks like you're doing what you need to do and staying compliant, so I appreciate that. I'll give you another review hearing date.
Could you keep them on Friday if possible?
Yes, sir. March 22nd. March 22nd will be your next hearing. You're doing well, Mr. Abrams. Keep it up. And see you clerk make your payment.
Thank you, Your Honor.
You're welcome.
Good day.
Jason Collier. Jason Collier is at RRS, intensive outpatient. Negative drug screens.
Your Honor, he is compliant. I don't know why he is not here today.
Okay. And he is working.
Yes.
Okay, so I'm gonna, what I'm gonna do, I'm gonna continue it and give him a chance to get in here without issuing a warrant. Because he's compliant and doing what he's supposed to. I'll set it February 26th, if you can let him know. He needs to be here February 26th at 9 a.m.
Thank you, Your Honor.
Thank you. Aaron Cottrell. 23-352, that's the case number. He's done nothing on his case, has not appeared today, so there'll be a warrant for failure to appear. Russell Daniels is here, 23-501. How are you, Mr. Daniels?
I'm better than I deserve.
Good. They've got a certificate of completion and negative screens, so it's good. And you've already paid your fines and court costs.
Yes, sir.
Okay, so what I'm going to do, you've done everything up to this point the court's required, and you have completed your course of treatment, so I'm going to complete your case and complete your probation. So congratulations on that. I think you've done very well. And just as a note of caution, the work's not over though. I think you realize that. You got to keep working at this, but I'm just not going to monitor it anymore because I think my role is completed. You've got a lot of good people surrounding you. You rely on them and that community, I think.
Yep.
And hope you do well.
Well, I took your advice.
Good.
Yeah. Abstinence is the best policy.
Well, you know, that's, of course, science is constantly changing, but the new science is coming out is, and I think I discussed this with you before, because there used to be some thinking that a moderate amount of alcohol could actually be good for you in terms of like cholesterol and that sort of things, but the newer science that's coming out now is that there's no amount of alcohol. That's good. It's toxic, and it's damaging to the cells, and abstinence is the best policy. So,
Correct.
So I think that's, and there are certain people, and you might be one of them, I don't know, that it's particularly toxic for. So
Low tolerance.
yes, and just don't, you know, some people can take a drink or two and that's it, and there's other people like they don't stop at one or two. Once they get a little bit, they're off the reservation. So it's about 10% of folks that have that problem with alcohol. So, and I just saw a study, you know, and I am concerned about substance use and the drugs in our community, but you know, and it is a big deal, but more people die from alcohol abuse in our country, substantially more every year than drugs. Alcohol is the #1 toxic substance in our community. So, but you've done well. Congratulations. Go on and do great things.
I appreciate you.
Thank you, sir.
Thank you.
Okay, Donald Dickus is here, 23-104 and 105.
Yes, sir.
Okay, I've got a report from Anu for you, and it's a very good report. So, you've paid all your fines and court costs, and you've had a couple of really good reports from them, so I'm going to terminate your probation too. Your case is going to be completed. Just my observation, Anu's been very good for you. I hope you'll voluntarily continue to go with them, because it seems like they're helping you a lot, but I'm not going to require you to report back to me that you're doing it.
I have no problem with that.
Okay. Your case is completed, sir. Congratulations.
Well, you have a good retirement, sir.
I'm not there yet, but it's
Well, you're working on it.
6 more years.
Thank you, sir. Oh, well, okay. I hope
If I live there.
I hope I don't see you again.
Yeah. You can come back and visit anytime. We're open to the public. Cameron Harless. Okay, we've got signed by teleconference. Let's see. Is Cameron Harless on the telephone? Okay, it's not Cameron Harless, and he's with RRS also. It's a pretty good report. I wouldn't say it's a perfect report, but it's a pretty good report. Any idea why he's not here today?
No, Your Honor.
Okay. He's done nothing else on his case, so I'm going to give him 7 days. He's got 7 days to get in here. And if he doesn't, then a warrant's going to issue.
I'll get him in here.
Thank you.
Thank you, Your Honor.
Cameron Krantz, Stephanie Romans, Bobby Rose, Hannah Settles, Robert Myers Jr., Sarah Woods.
Cameron Krantz. 23,695. Cameron Krantz.
Your Honor, if I may, I have note that Cameron Krantz was ordered on January 8th as a community service on the court day and has not showed up.
All right, there'll be a warrant issued for failure to appear. He hasn't done anything else in this case either. So. Stephanie Romans is here, 1730-10. She's at Bethesda.
She does all community service.
Okay, great. She's done quite a bit of community service since the last hearing. Looks like there's some issues though at Bethesda. So, what can we do about that? It just sounds like it's a little keeping up with local rules and things like that.
Yes, she's close to graduating, so hopefully she gets herself back on track and we can move forward.
We're gonna do that?
Yes, sir.
Okay, when do you think she'll graduate?
Well, it's too soon to say just yet.
Okay. But it's on the horizon.
It's on the horizon, yes.
Okay. Well, I think I've known you for a while. And you've had periods here lately that this is the best you've ever done, right? Do you agree with that?
Yes.
So you're close to finishing up. Let's finish it up the right way.
Okay.
Okay? Let's do that, and then, there's still a lot of work to do because you're going to have to get a job, you're going to have to get housing, all that.
I already have a job.
Okay, you're working now. Okay, wonderful. I want to see you in a month, so I'll make it March 15th,
Thank you, Your Honor.
9 o'clock. Bobby Rose, 23501, 501, 23501. He's not appeared and he hasn't done anything on his case, so he gets warrant. Hannah Suttles, 23430 is here.
Your Honor, if I may, Ms. Suttles was ordered on January 5th to be here on January 6th and has not showed up.
What say you, Ms. Suttles?
I went to the dog pound on Tuesday and was done a few hours of community service. And then, but the 6th, I ended up having to do a training for work that weekend, so I wasn't able, I had to drive to Wellston.
Okay. Who are you working for?
Circular Health,
So it's home health?
yes.
Okay. Can you verify if she's done anything for
I can
dog?
make the phone call when I get a chance, Your Honor.
Okay. Have a seat. I'm going to verify because I have no report from the dog pound that you've been there, so I'm going to verify that and we'll recall you when we get there.
Okay.
Just have a seat. Robert Byers, Jr., 22-2120. Is that new life recovery? Community services done? So your report working and lowering your MAT requirements, right?
Yes, sir.
Eventually going to go totally off of MAT?
Yeah, I'm fixing to drop 2 milligram. I'll see the doctor this time, and hopefully by May be off of them.
Okay, very good. Can you pay anything on your fines today?
I got $20.
See the clerk, make your payment. You're doing good with your treatment. Keep that up. What's best for your work as far as?
Monday's probably, Your Honor.
Monday's better? Okay. Let's look for a Monday, end of March. March 25th.
Thanks, sir.
Thank you. Keep up the good work.
Uh-huh.
See the clerk. Sarah Woods. Okay, she's on teleconference.
Permission to approach, Your Honor.
Yes, you got a report for her.
Yes, sir.
Case numbers 22-326 and 21-686.
In regards to the report, Your Honor, I received confirmation from medical staff that the screen is negative.
Okay, very good.
It appears to be a medication false positive.
Okay, so she had a send-off screen. And,
Correct.
Verified it was negative, so that's good. All right,
They can't, we got a note in the clerk's office that they can't hear on Zoom.
okay. Let's see. I have Miss Woods that you are muted. So I think the audio should be from that computer, shouldn't it? Will we have Mr. Major come in and look at that?
Yes.
Okay. So we'll come back to Mr. Woods when we get the audio working. Is that, you know, the reviews?
Yes.
Okay, we're gonna. No, they're not getting audio on the other end.
Okay.
I'm sending them a message
Yeah.
that we're trying to fix. Okay. The next thing are going to be the arraignments. That's for new cases. If you're here for that, your name's going to be called. Come up to the table to the right, stand there. We're going to go over your file with you, the charges. You have a right to remain silent. You don't have to say anything. If you choose to make any statements, what you say is on the record. So if you get up and say, yeah, I did it, the prosecutor can use that against you. You have a right to have an attorney. You have a right to have one appointed if you can't afford one, to have bail, to make the state prove any charge against you beyond a reasonable doubt. Those are rights that all defendants have. If you enter a guilty plea or a no contest plea, you're giving up those rights, and you should not give up your rights if you don't understand the proceedings, if you're confused about what's happening, if you want to talk to a lawyer, or if you don't know what to do or want a trial, you should enter a not guilty plea. Not guilty. Okay. Not guilty is always the safest plea to enter. Okay, so let's go back to, let's try to finish these up. Ms. Woods, can you hear me now? Sarah Woods, and yes.
This is Ms. Weaver.
Okay, I'm looking for Sarah Woods. She's on the screen. Sarah Woods. You're muted. Ms. Woods, your microphone's muted. Okay, can you speak, please? Okay. But, see, other people that are on here, I've got, who was the other person that spoke just a minute ago?
Miss Weaver, it's not good to me.
Okay. Who was the gentleman that spoke? Aaron Thompson? Cottrell, Aaron Cottrell. Okay, so you can hear me then, Mr. Cottrell?
Here and there, yes, sir.
Okay. All right, well, we'll continue to work on it. Now I see Sarah. Okay, Aaron Cottrell was set for a review hearing, so let's go ahead and do that. You have a theft offense. And you were supposed to go to the counseling center. Did you do that?
Yes, I'm at the well, I'm not there today, I've not got a meeting or nothing. But yes, I'm at the counseling center.
Okay, well, I need a report from them about what you're doing there.
Okay, I just signed a bunch of, I just got a new case manager yesterday. My meeting will be with them Tuesday. I had to sign a bunch of ROIs, which is release of information forms, that way they can send you stuff.
Okay. Have them send me something, and I'm going to set your next hearing for March the 4th, so give me a report by then. Where are you living now, Mr. Cottrell? Are you living in
South Ohio.
Where?
South.
Is that Scioto County?
South Ohio.
Is that in Scioto County?
Yes.
Okay. Well, I'll let you appear by teleconference because of that. Your next hearing is March the 4th at 9 a.m. Can't cancel any warrant I said before.
And do it on Zoom?
You can do it on Zoom.
Okay, thank you.
You're welcome. All right, Sarah Woods. Can you hear me?
Can you hear me, sir?
I can hear you, yes. Can you hear me?
Okay. Yes, sir.
Okay, so this is your review on case numbers
Sorry.
22-326. We had a problem with the audio. We got to fix now. 21-686.
Yes.
And I do have a report from Minda Reeds saying that you are compliant.
Correct.
So you continue with that. You've got some community service and fines to pay. You're going to have to deal with those too. Your sobriety is the main thing at this point.
I'm paying $40 a day.
Okay. I'll set March 22nd as your next hearing.
I'm gonna make a payment of,
Okay, you said $40, so we'll be looking for that. March 22nd is your next hearing. Hopefully she can still hear me. Did you hear me?
Yes.
You got your-
Yes, sir.
All right, March 22nd, 9 a.m. is your next hearing.
Thank you, Your Honor.
You're welcome.
I can't hear, Your Honor.
What's your name, ma'am?
Melissa Weaver.
Your Honor, I have that file, she just needs to contact me.
You'll need to call the probation office, 867-3127.
I'm not sure what the extension is.
Okay, and go to the extension for probation
Okay,
and talk to Mr. Major.
okay. Thank you.
You're welcome. Okay, call the arraignments.
State of Ohio versus Daniel Craig Collier, case number TRC 23448, A, B, and C. He is on Zoom, Your Honor.
All right, we need Mr. Steyer in the courtroom.
Can you hear me, sir?
Yes, I can. We're waiting on your lawyer.
Yes, sir.
Your lawyer's here. He's coming in the courtroom now.
Yes, sir. Thank you.
You're welcome. And Mr. Steyer, this is Daniel Collier.
May I approach, Your Honor?
Yes.
I have, a report and some drug screens from Sky Point, which is where he's currently receiving treatment. I'm going to ask these to be entered under seal.
Okay. And it looks like he's going into a more intensive program later this month. In the report.
Well, I don't know, how IOP versus sober living, I'm not
I'm just
certain.
that he's going to be graduating later this month. Okay.
And then going to IOP,
Yeah,
yeah.
going to IOP. So. All right, I'll withdraw. I think there's been a warrant.
There has been a warrant.
Previously for missing a hearing, so I'll withdraw that since he's back in treatment. And I'll set his next hearing for March 15th. That's a Friday, Mr. Collier, March the 15th.
Yes, sir.
At 9 a.m.
Can I say this, that, they're transferring me back to Springfield to IOP?
Yes, I saw that in the report.
And
You can appear by teleconference like you.
that was the question I was gonna ask.
Yeah,
We have access to teleconferencing then?
yes, sir.
Okay.
And this will be, is this the same agency that you'll be with in IOP, or is it a different agency?
It'll be a different one, it'll be called McKinley Hall.
So you'll need to take the steps again to be able to get them to release the records?
Yes, sir, yeah.
All right,
Okay, all right. You're reinstated, Mr. Collier. March 15th is your next hearing.
thank you.
9 o'clock. You're welcome.
At 10 a.m.?
9.
10 a.m. I'm sorry.
Okay, we'll keep it on there at 9.
Okay.
9? Okay.
Okay.
Yeah, we'll wait a little bit.
State of Ohio versus Charles DeFore, case number TRC 24369, A, B, and C.
Sir, are you Charles DeFore?
Yes, sir.
Mr. DeFore, it's alleged on February the 10th at 3:23 a.m. in Perry Township, you were driving a motor vehicle while you were under the influence of alcohol, that you took a breath test and tested 11 on a breath test, and that this would be your first offense. On a first offense, the maximum penalty is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most the court can impose as a penalty if you're found guilty. There is a minimum penalty on this offense, which the court won't go below if you're found guilty. The minimum is 3 days in a treatment program, $375 fine, and a 6-month license suspension. You understand the possible penalty?
Yes, sir.
And then the test score, I want to explain that to you. An 11 test score is over what's called the per se level under Ohio law. Under Ohio law, a test score above 8 is considered per se a violation if, and this is a big if the state followed the rules for giving the test. There are certain rules they have to follow, like calibration and that sort of thing, to get the presumption of impairment. But if they follow those rules, any test above 8 is presumed to be repaired. They're saying you tested 11. You have 2 other charges. Speeding, so as you were driving 67 miles an hour in a 55 zone, that is a minor misdemeanor, maximum penalty $150 fine, and that you were driving outside your lane, that's a minor misdemeanor, maximum penalty $150 fine. So you have 3 charges. Do you understand the charges?
Yep.
Do you understand your rights?
Yes, sir.
How do you wish to plead to these charges?
Not guilty.
You want a lawyer appointed to represent you?
No.
Are you going to hire a lawyer?
Yes, sir.
How much time do you need to do that?
Probably a couple weeks.
I'm sorry.
Probably a couple weeks.
Yeah, well, I'm going to go into March. That's when we're setting.
Okay.
Are you employed, sir?
Yes, sir.
What's better for your work schedule to come back? Court is usually on Mondays and Fridays, so when would you wish to come back for a hearing?
Monday, preferably.
Mondays are better?
Yeah.
Let's make it March 4th then. March the 4th will be your next hearing. That's a little more than 2 weeks away. Now, it's going to be a pre-trial at 10 a.m. on March 4th. I'm entering a not guilty plea for you. And I don't think you posted any kind of bond, did you?
I ain't good. They just
They didn't
released
ask
it
for a
like
bond.
10 minutes
Okay,
later.
I'll let you sign a signature bond of $1,500. And what that means is you're signing a piece of paper that says, I promise to come to court, or I'll pay a $1,500 penalty for not showing up, plus you get a warrant. So just come to court. You won't have to post any money as long as you appear as directed. And I'll put down that you're going to hire an attorney. Any questions, sir?
No, sir.
Okay, March the 4th, 10 a.m. is your next hearing.
All right, thanks.
You're welcome.
State of Ohio versus Brian K. Anderson, case number CRB 2437.
That's that one that we were just talking about.
Have you received a copy of the charge, Mr.
Nope.
Anderson? Okay, and I don't, we're going to need to, why don't you just have a seat, I need copies made, so I don't have an extra copy in the file.
State of Ohio versus Chad Campbell, case number CRB 22814, TRC 222782, A and B.
All right, Mr. Campbell, you're Chad Campbell?
Yes, sir.
You had a review hearing on Monday, it looks like that you missed, is that right?
Yes. I couldn't find a babysitter.
Okay. You have paid your fines, you've done one of your days of community service, is that right? So
Yes,
that's-
and I'm gonna come and do a day tomorrow too.
All right. I'll not issue a warrant for you for missing Monday then. I'll reinstate you, give you another hearing date. You get this finished up before the next hearing date, you don't have to come back.
Okay.
March 22nd. If you finish it before then, you don't have to appear. That's at 9 a.m. on March 22nd.
Okay, thank you.
You're welcome.
State of Ohio versus Amanda Hicks, case numbers TRD 121804, CRB 12456, CRB 08162.
All right, Amanda Hicks is here. This is on, she had a review hearing on Monday also. Do you admit you missed Monday?
Yes.
Do you have an explanation?
I was in the hospital
And I just sent my mom, because I didn't bring my paperwork with me, I sent her a message to send me a picture of my release date and stuff. And my mom's 75, and she's trying to figure out how to work her camera, so.
Okay, we'll get that and
I was in there for
give it to
7 days.
give it to your probation officer, Mr. Major.
Okay.
Do you have any payment on your fines today?
Yeah, I'm gonna pay $50 whenever I leave.
Okay. We'll see the clerk to make your payment, no warrant to be issued for missing Monday.
Thank you, and I'll make sure I bring proof.
Okay, next hearing, March 15th,
Okay.
9 a.m.
All right, thanks.
See the clerk,
All right, let me write this down.
March 15th.
State of Ohio recalls Brian Anderson, case number CRB 2437.
All right, we have an extra copy now to serve Mr. Anderson with. He's been handed a copy of the complaint. And you are Brian K. Anderson?
Yep.
Mr. Anderson, it's alleged that at Perry Township on January 13th, 2024, you knowingly caused Shannon McPherson to believe that you would cause serious physical harm to her person or property. The charge against you is aggravated menacing. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand this charge?
Yes, sir.
Do you understand your rights?
Yep.
How do you plead to this charge?
Not guilty.
You want to be considered for a court-appointed lawyer?
Yes.
Are you working?
No.
You have no income?
I got retirement.
Okay, how much is that a month?
I can't remember off that.
Give me a ballpark.
After all the deduction, 815.
Okay, you're eligible for court-appointed counsel then.
Available.
I'll appoint Mr. Stratton to represent you. We'll have him come in the courtroom so you can meet him.
Good morning, Your
Good
Honor.
morning, Mr. Stratton. This is Brian Anderson. He has an aggravated menacing charge, making a not guilty plea for him. You're appointed to represent him. I'm assuming the states want some kind of protection order on this.
There's not at this time, sir.
Okay. Not guilty plea is entered.
Yes.
He can sign a $1,500 signature bond.
Sign right there. You didn't post a bond, did you?
Huh?
You didn't post a bond?
No. My else.
Okay, the dates that would be best for the court would be the 1st, 8th, or 15th,
Your Honor, this
all Fridays.
probably the first week in March, whatever. Oh, you said they're all Fridays?
Yeah, those are
Oh,
all.
any Friday.
Okay, March the 1st.
Okay.
March the 1st will be the pretrial at 10 a.m.
All right, thank you, Your Honor. We'll see you outside.
State of Ohio versus Joshua M. Hay, case number CRB 21324.
And this was set for a review on Monday, as Mr. Hay wasn't here. Do you admit that, or
Yes, Your Honor.
do you have an explanation for not being here Monday?
I was working hanging drywall and I had to do some testing with probation. I just forgot about it.
And you did make a payment today on your funds. I'll not issue a warrant. I'll give your next hearing as March the 15th for your next review.
Thank you, Your Honor.
March 15th, 9 o'clock, your next hearing.
Thank you.
You're welcome.
State of Ohio versus James Gilkerson, case number CRB 2476.
Sir, you're James Gilkerson?
Yes, sir.
Have you received a copy of the charge?
No, sir.
I've got an extra one. The bailiff will serve you with a copy of the charge. It alleges that on February 5th, 2024, in Fayette Township, you knowingly caused or tried to cause physical harm to Christine Seek, and that she's either a member of your household or a member of your family. So that is a first-degree misdemeanor domestic violence charge. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand this charge?
Yeah, but I don't.
You don't have to agree with it, but you need to understand it. It may be totally false.
Yes, sir, I
But you
do
need to
understand.
what's alleged. You understand what's alleged. Mr. Gilkerson, you understand the?
Yes, yes, sir.
You understand the rights you have as a defendant that I explained at the beginning of court? You want me to go?
I've never done anything like this, sir.
Okay. You've heard this 1,000 times if you've watched any TV shows. It comes from a very famous U.S. Supreme Court case called Arizona versus Miranda, which happened in the 60s, 1960s. You have a right to, which said defendants had to be given their rights by police officers before they're taken into custody. You have a right to remain silent. If you choose to make statements, whatever you say is on the record, it can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail. You have a right to make the state prove any charge against you beyond a reasonable doubt. Do you understand those things?
Yes, sir.
How do you wish to plead to this charge?
Not guilty.
You want a lawyer appointed to represent you?
Yes, sir.
You're not working, I take it?
I'm on disability, sir.
Social Security? That's your only income?
SSID, yes.
I'll appoint Mr. Scott to represent you. We'll get him in the courtroom. Is there a protection order requested on this case?
Your Honor, the alleged victim has indicated that she does not want a protection order.
It's not one. Is she here today? Is
Yes.
Christine Seek here? Ma'am, why don't you come up? I think it might be helpful if we spoke to the prosecutor for a moment while we get started. Yeah, right here. That's Mr. Heald is the prosecuting attorney. Okay, Mr. Gilkson, no, we need Mr. Scott. Is he here?
Yes.
Mr. Scott, we need you in the courtroom, please.
He's coming. He's coming.
Apologies, Judge, I was on the record in Portsmouth.
All right, this is James Gilkerson. I'm appointing you to represent him. It's a domestic violence charge.
Yeah, DD charge.
I guess I've never had one.
All right, Judge, under not guilty plea on the issue of bond, imagine a temporary stay, a wait order would be effective.
I don't think she wants a protection order, so there'll be a signature bond.
Okay.
$1,500. Cash or surety.
Yeah, Random X. Judge, I'm looking at a new date. I'm down here on March 8th.
That'll work. See what Mr. Heald has to say.
Your Honor, we're not opposed to an OR bond.
He can sign a $1,500 signature bond.
Hey, goodbye.
And we're looking at March the 8th as the next pretrial. She doesn't want her protection orders, I understand.
She does not.
Okay. March 8th will be the next hearing for pretrial at 10 a.m.
304 651 1840. Can I speak to you?
Yeah, yes, well, be able to, okay. All right, thank you, Judge.
That's all.
Thank you.
You're welcome.
State of Ohio versus Kyle L. Akers, case number PRC 22 25 27, A and B.
All right, this is on a bond forfeiture. Mr. Sowers is here.
Morning, Your Honor.
Good morning. Any location on Mr. Akers?
Yes, Your Honor, I know exactly where he is. He, if you recall, he's the one, he had to hold her out of the mags, and
okay.
we finally got him the mags, and they incarcerated him there at the Gallia County Jail for the duration of his case, but now he's been sentenced to Star. So he is at Star on Meigs County's directive, so.
All right, well, on the basis of that, we should be able to get him back, I would think, if he's in Star. So I'm going to release you from the bond, and we'll just need to make sure Star's aware of his warrants and send him back to Lawrence County once he's available.
Okay, thank you, Your Honor.
Bond is released.
State of Ohio versus Patrick S. Jones, case number TRC 19378, A, B, and C.
This is also on a bond forfeiture, same issue and question you, Mr. Sowers, did have a location on Mr. Jones.
Well, we're playing cat and mouse, and the cat will always catch the mouse eventually, so.
So you're not giving up on him?
No, sir, Your Honor.
Okay, well, I'll give you some more time. March 15th?
Sure, that'd be great.
March 15th will be the next bond forfeiture hearing, 10 o'clock.
State of Ohio versus William Hall Jr., case number CRB 23229 and CRB 23204.
Also, bond forfeiture for today, Mr. Sellers.
Your Honor, he has been sentenced to prison in Ohio on a third-degree felony charge. It looks like his admission date was January 12th. No,
Yes, I actually have something in the file.
That is incorrect. He is in Lorraine Correctional Institution, though.
Right, that's what the information I have. So I wonder if the state even wants to continue. These are both misdemeanors. Does the state even want to continue to pursue these, or do you want to dismiss them?
I'm sorry, I wasn't paying attention to
This
what...
gentleman has domestic violence case here and a protection order case, but he's been sentenced to prison in Ohio and is at the Lorraine Correctional Institute right now.
And what's his name?
His name is William E. Hall Jr.
Your Honor, I think it says here he has a definite term of 4 years.
What we would want to do probably ultimately is dismiss the charges, but we're going to need to consult with the alleged victim and make sure that that person understands. So if we could continue that.
Let's just put it on March 15th. Mr. Sowers is going to be back for the other cases. I'll continue to March 15th, let the state look into it, how they want to handle it, and maybe it'll be dismissed or some handling then that gets Mr. Sowers off the bond, since it's going to be impossible for him to get Mr. Hall back here since he's incarcerated in the prison system right now.
Makes it very difficult.
Yes. Thank you.
State of Ohio recalls Cameron Harris, case number TRC 2348, A, B, and C.
Okay, this was set earlier for a review. Mr. Harless is here now.
Your Honor, he got his times confused. He thought it was a 10.
Okay, and you'd already given me a report that he's
Yes.
doing very well. Need to get out here and do some community service. Is there any possibility of that?
Yes, sir. I've been working through a temp agency, and the ticket I got on at the end of December, and my ticket expires after Wednesday, so I was going to start it after Wednesday.
Okay, get out here and get some done. I'll set your next hearing. March 29th.
Thank you,
Last
Your Honor.
Friday in March. March 29th, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Good work. Okay, we're starting the pretrial docket now.
State of Ohio versus Emily McCoy, case number TRD 193655, A and B.
Good morning, Your Honor.
Good morning. This is, Mr. Smith's case.
Permission to approach, Your Honor.
Yes. My summary of this is she's doing well, making good progress, and still has things she's working on.
Correct.
In speaking with her, Judge, she thinks she's probably 5 or 6 weeks out from graduation. Does that sound about right?
Okay.
Approximately based on proper compliance, yes.
Okay.
We'll set a review around that time.
That's what I was hoping to do, Your Honor.
Maybe 6 weeks out. 29th of March, are you available?
Is that possibly a Friday?
That's a Friday.
It is a Friday. Yeah, I am available, Judge, yes.
March 29th will be your
29th
next
at 10.
hearing for sentencing. Good job, man. Support.
Thank you very much.
Good up.
Absolutely. I hope to go back to work very soon.
Great.
State of Ohio versus Cody J.W. Mead, case number TRC 23152, A, B, and C, PRC 221690, A and B. Cody Mead.
May I approach?
Yes.
It's up to the judge. Okay. I mean, we're willing to do whatever. I do recommend this all.
Okay.
But it's in pre-trials.
Yeah, it is.
I'd like to go to OVP, so closer to my house, be closer to home, more away and fight them. I'll ask the judge. Okay.
Is it also preliminaries?
But you're not doing mental health right now.
No, I'm just dealing
He's declined because he wants to be in a 2.5 service before he starts.
Well, Mr. Mead has two, I believe he has 2 ODIs. Well, one he's already been sentenced on, and then another one's pending.
I think that's correct, Judge, yes, sir.
Let's say, 23 TRC.
152.
Judge, in speaking with Ms. Nagel from Cardinal and my client, he wants to go to OVP. Cardinal is willing to keep him there if that's Your Honor's decision, or if it's OVP, I'm not speaking on that, Ms. Nagel, but they're good either way.
I've got it in my judgment entry, this is a year ago, that he was under some sort of concurrent jurisdiction with the common police court. Is that still pending or not?
No, I took 7 months to kill my felony out. I took time on the shelf. I'm just down in misdemeanor court now, that's it.
What do you mean kill it out? Were you in jail or what happened?
Yeah, jail, yes, sir. Huh? I think I'll leave. Okay. I was not his counsel on that one, Judge, so I can't enlighten the court
Which
on what
common police
happened.
court was that?
Right here in Ironton.
In
Ballard
Ironton?
was the judge, yep. It may have been Mr. Steyer's case, he thinks.
The only
Cody
involvement
Mead.
that he has with the common police now is the ankle monitor we report.
Your Honor, if I may, he was just here a week or two ago, and he was in custody in the back. And we ordered an ankle monitor on him at that time to go to inpatient treatment.
No, I don't believe this was mine.
Tall old man with a humpback. Mr. Morford.
Yeah, yeah. I think it's him.
So this is his position.
His sentence was actually entered initially February 24th of 23, so we're talking about a year ago.
It is Mr. Morford was his counsel. I'm sorry, comment please, not Mr. Steyer.
To kill out my jail time.
Then he just got ordered to inpatient treatment in January of this year. And it sounds like, from what I'm reading, basically it was a detox at the beginning.
Yes, he has stayed at the detox. That's where I picked him up from today until you made your decision on. But we can also keep him at the detox for stabilization of 3.5 care as well, to focus more on the mental health.
He failed to appear for his review in November of 23 and got arrested in January. And went for detox. And he's on Vivitrol now.
Yes.
So this is a pretty serious issue. Yeah, he got sentenced on 2 OBIs at the same time. And you were already in jail at that time on the common pleas order. So, I think he, under the circumstances, I think he needs to do whatever is being recommended for him. And I'm going to assume it's longer than a 30-day program.
Yes.
So I will not agree with him going to ODP.
Now, as far as I can put him at our Ironton location so he can be closer to home with the kids. But
That's
yes,
fine.
it's definitely our recommendation for more than a 30-day program.
Okay. Let's come back in another month and see where he is there. March the 15th will be the next hearing. Pre-trial and review, 9 o'clock or 10 o'clock.
You said March what?
March 15th.
State of Ohio versus Walker Panel, case number CRV 2423.
Mr. Smith's case, and it's set as a pre-trial.
Yeah, should we approach on that?
Approach, Judge.
Yes.
Judge, he has West Virginia Blue Cross Blue Shield. We talked about this. I don't know. It's above my pay grade to figure out who can do that, but he's willing to do that.
Okay, so
They
what I'm
speak to
going to
someone.
do, continue it for end of March, give him some chance to do some community service and get some medical evaluations that we discussed and come back and decide how to proceed then. So March 29th?
I'm here that day, yes.
March 29th will be the next hearing, 10 o'clock. And he can do that through the court.
Okay.
How much community service?
Well, I'm not going to, I'd say at least 40 hours.
Okay. You need to see Josh Brooks. Make sure they get done. So here, put out here, the machines are. He's going to talk to you. Thank you, Judge.
State of Ohio versus Branson Johnson, case number CRA 2463.
Do that entry.
Your Honor, he has been picked up.
All right, Branson Johnson has a warrant out of Pike County. He was picked up by Pike County from the jail, so the case here can be dismissed.
State of Ohio versus Christopher Blackard, case number TRC 17-1226, A, B, C, and D.
Mr. Stratton's case set for pre-trial.
We're just resetting this. Your Honor, we still need to file for discovery in this case, this first pretrial in this matter, so we just asked it to be reset, maybe somewhere in the middle or the later part of March, and we'll waive time.
Now, I know you said you were fine with Fridays, but you are here on Monday, so too, right?
Your Honor, this latter part of February and the first couple of weeks of March, I have trials on Mondays, so yeah, I'm here on Mondays too.
How about the 18th?
Yeah, that's
You're
your
here the 18th, March 18th will be the next one.
just trial season, Your Honor.
Okay. March 18th,
March
10 o'clock
18th.
will be the next pre-trial.
All right, March 18th.
State of Ohio versus Gregory Fairchild, case number CRB 2451. Gregory Fairchild.
Hey, Greg.
Mr. Stratton's case set for pre-trial.
Your Honor, I don't know if the prosecutors had any contact with the alleged victim in this case, but
We will issue a subpoena for her and come back at the next, see if we can get her here for the next
She's
hearing.
not here today, I think.
I don't believe so. Is this Ethan? Ethan Brewer? We sent a card. Apparently this person either didn't get it or hasn't responded, so. Now this is an M4 alleged to have happened 16 days ago. 17 days ago.
Okay, well, do you want to come back quickly, or do you want to enter a time waiver, Mr. Stratton?
well, we'll enter a time waiver, Your Honor, because I think we're going to eventually resolve this. It's not as serious as others, so I think we'll be able to resolve this.
March 1st then?
Yes, March 1st is.
March 1st will be the next hearing. Pre-trial, state's going to subpoena the complaining party to be here for that hearing.
State of Ohio versus Stephen Fletcher, case number CRB 23705.
This is Mr. Stratton's case set for pre-trial.
Your Honor, may I approach?
Yes.
Your Honor, I believe that the prosecutor still needs to speak with the alleged victim in this case, and also get some information from her. And there's also some videos which we've seen some videos, but we haven't seen other videos that we need to see. So
We've given them to you, but you haven't opened them or haven't tried
well,
them.
we got one batch, and then I just got another batch.
We got some videos from the homeowner, the alleged victim in this case, and I say homeowner because it happened at her home, and we have security camera video that it's going to take a little bit of work to figure out how to open them. And she's actually here today, and I've spoken with her today, and I've told her I'm going to talk to her on the phone more, but we'll have a better opportunity to get this, hopefully copies of the videos that can be viewed. So we're working on that.
How long do you think it'll take to get those videos in shape where you can share them?
How many are there, do you know?
There's a whole bunch of them. Actually, we've shared them, but they're in a format that requires some other additional program to play. So you may be able to open them.
Well, I was able to open the two videos that we have, the main videos, but these other shorter videos you said happen throughout the day, I have not.
Okay.
So.
Have you tried to, or?
Yeah, I think I have, but anyway.
Some of them can be open, some of them, they're in a different, whatever. Anyway, we'll work on it. A couple of weeks.
You need to get a 12-year-old on your staff.
No question.
And the prosecutor.
No question.
They'd be able to open it.
So yeah, like 2 weeks.
Okay. March 1st. I think Mr. Stratton's already here then.
Yes, March 1st.
March 1st, these next year.
State of Ohio versus Tiffany Gonzalez, case number CRV 23784.
Your Honor, Tiffany Gonzalez and her boyfriend Cecil Gordon, who is also on the docket, probably next, are stuck in Nicholsville, Kentucky, and they don't have available video. Last time we were here, they appeared by video. So I asked to be reset for both of them, but
State of Ohio versus Cecil R. Gordon, case number CRV 23719.
Oh, you're representing both of them?
yes.
Okay. Mr. Hill, your position?
We're not opposed to a continuance. I would like to know if, Mr. Stratton, did you file discovery on these?
I believe in Cecil's case I did, but I have to check and see if I did.
So I want to make sure that we have
We'll have a resolution next hearing, Your Honor, on this matter.
What's the other guy's name?
Cecil Gordon.
Cecil Gordon. It's my record that there's been some of the time run against the defendant already, so of course this next time frame will run against the defendant.
Yes, yeah. We already signed that waiver, Your Honor.
March 1st then?
Yes.
March 1st for pretrial.
And we do have the video in the Gordon, so that should be the same video as the other case.
State of Ohio versus Harold Maynard, case number CRV 23773, A and B.
Your Honor, I think that after he's at Bethesda, and prosecution has agreed that if he completes his treatment at Bethesda, that they're willing to dismiss this with cost. So,
Okay.
which might be a little bit, so maybe come back in a month.
March 15th?
Yes.
March 15th will be the next hearing. Looks like you're on the right track, Mr. Mayor. Good report.
Thank you, Your Honor.
State of Ohio versus Joseph W. Rice, case number CRB 2426.
Okay. Mr. Price is Mr. Stratton's case, pre-trial.
The last one was we said that March 18th.
Your Honor, after speaking with the prosecutor, they've agreed to do a 90-day dismissal on this. If he completes anger management, they want to keep the protection order in place. Yeah. So, who do you want him to go through with the anger management?
How do you pay for medical services?
I have Medicaid.
Okay. You live in Ironton?
I live in Pedro, Ohio.
Okay. Who could accept your RRS, which is in Chesapeake?
I have one in South Point.
Okay, Chesapeake or South Point, where would you prefer to go?
South Point.
Okay. Speak to Taylor about getting that set up, that'll be at Bethesda. And let's make it a little more than a month, the 15th, probably getting busy now. The 22nd, March 22nd?
Yes, sir.
Will I have more information on this?
Speak to
So let's get a report in as to how it's doing.
Your Honor, we did consult with the alleged victim in this, and she was in favor of this resolution.
Okay.
But we are also expecting, if he completes the counseling, payment of court costs and no further problems, for us to agree to dismiss the charges that were entertained.
Yeah, no problem with that, Your Honor.
That's agreeable.
That's agreeable.
All right, thank you.
State of Ohio versus Angela Badgett, case number CRB 2480. Mr. Morphy's case.
Mr. Morford's case set for pre-trial.
This evaluation is not all that you really do. Well, you're going to have to get some. See if he can refer. I want to know about all of it.
I did get that information. I talked to him and told him what I needed.
Well, I think I want the psychiatric evaluation. That's all. Says no psychiatric diagnosis.
That's what that one was.
No psychiatric.
Because I explained to him what had happened, and I didn't get that information.
But we continue, that's what I have to do.
Okay.
I don't know what other people should do.
My notes on this case were, could be dismissed with costs if she got some assessment and counseling, and we're looking at value off WP or ProAct. So my notes, did any of that happen?
Some of it has, Judge. She has had a psychiatric examination, evaluation done. Mr. Hill this morning had a look at it, and they want alcohol and other drug assessment, as well as anger management. I've explained that to Ms. Badgett, and we're trying to figure out where she can get those done. OBP, I understand, doesn't do anger management assessments. So I don't know if we can find one place.
Where is she going today?
OBP, Your Honor.
Okay. Is that correct? If it's not, it is related to substance use, or looking at Bree?
We can do the alcohol and drug assessment, we just don't offer it, the anger management.
Okay, thank you. And as I recall, she has some sort of health insurance, I think.
Blue Cross Blue Shield, Your Honor.
Okay. Well, we could try Valley Health or ProLab. Those are other agencies that take health insurance.
Do you have a preference? She doesn't have a preference.
Both of them are in Huntington. Well, I'll let her make the decision. I mean, they're both medical facilities. Mr. Hill, do you have any input on this?
Well, we'd like her to be at a place where we know we can get regular reports. That's number one. Number two, I don't know whether, if there are alcohol issues, that might have play such an important part in the anger issues, that the alcohol is more important. I don't know what the issues are at this point, but we do want her to follow through.
She's willing to do that, Your Honor.
Okay. Come back in another month and see where we are then.
Please.
March 22nd. Pre-trial 10 o'clock.
State of Ohio versus James Smith, case number CRA 23559, CRB 23560, CRB 2340.
This is Mr. Morphin's case, pre-trial and preliminary hearing. We're going to start some arraignments after here in just a few minutes, so I need lawyers to stick around because we're going to have plenty of arraignments.
Judge, may I approach?
Yes.
Report from Pat. Very good report. You're welcome.
Okay, it's a good report.
What is it, sir?
Good report.
Thank you.
Okay, how's council wish to proceed on these cases?
Your Honor, it is a very good report, and we're pleased with Mr. Smith's progress and happy. Hopefully this is having a huge benefit for him and his life. I believe at this point what we'd like to do is go ahead and, we promised that we would dismiss these charges if he was successful in treatment. On the disorderly conduct charge, we'd go ahead and issue a nollie on that one. Just to,
And which case number is that? That 23560?
that's 2340.
2340.
And then that way it just narrows down what we're dealing with. The other one dealt with an alleged victim who has wanted him to seek the treatment and was not asking for a conviction. So we still, we want to make sure that everything's okay there. We don't have any indication that there have been any problems between them. But we would just want to have one more report that he's still doing well. And this may be something that he'll decide he needs ongoing indefinitely. But we doesn't mean we need to keep him in court indefinitely either.
I do wish to continue with the going through path. That was something that I do plan on doing. And as far as the alleged victim, if you all would like it, she can come speak or next time.
We've actually reached out to her. We don't have a phone number for her at the
Okay.
present time.
I have a phone number I could provide for you.
Can you write it down for us?
Absolutely.
And so what we would do then is maybe have her at the next hearing too, and if he gets another good report and she's satisfied that there haven't been any problems, maybe we'd look at a dismissal next time.
Okay.
The disruptive services, is that being continued also?
Yeah, that's 23,560 and 23,559 are been.
59.
Yeah. So the one that's dismissed is 2340. Knowledge. So let's look, maybe go further out into April.
Thank you, sir.
The next hearing.
Thank you.
What's your schedule like, Mr. Pointer?
Judge, I'm pretty free in April so far.
April 1st?
Again?
April 1st will be the next hearing for Mr. Smith. We'll look at a dismissal then.
Thanks, sir.
Yes, sir. We'll see you then.
All righty. Have a good one.
You as well. Thank you.
State of Ohio versus Stephen Stanley, case number CRD 23-148, CRD 22-184 A and B, CRD 19-33-37 A and B.
This is Mr. Morford's case for pretrial. Both reports seem positive. The one on the news says he's completed that Bethesda. I don't see that in the report.
No, that's not correct. He completes next month, or next month.
He's also completed 10 sessions of parenting classes, Judge, at Bethesda.
Okay, very good. How do you want to proceed?
I'd like to keep on the same path, Judge. He's clean and compliant at both Bethesda and Anu, as I would read it. And he's indicated to his providers that he wants to continue.
Mr. Hill?
It's a good report, and the alleged victim reports that there have been no problems. And we might be looking at a dismissal of the charge if he's going to finish his program at Bethesda.
The last Thursday of next month.
So then, if we got a report that he finished and there haven't been any further problems, we'd probably be in favor of a dismissal at that time.
maybe that April 1st date for this case also?
Yes, Judge.
April 1st will be the next hearing. For all Mr. Seaman's cases.
Thank you, Your Honor.
You're welcome.
sir. Okay, good luck.
State of Ohio versus Gavin Woodyard, case number TRC 24-150, A, B, and C.
Thank you, Coach.
Mr. Woodyard is 24-150. Do you have counsel, Mr. Woodyard?
I don't.
All right, this is set for a pre-trial. Are you going to hire a lawyer? How do you want to proceed? sir?
Yes, I was going to say if I can get a few more weeks to try to find a lawyer.
Okay, that's going to result in a time waiver, you understand that? And you have a right to make the state bring the case to trial in a certain time frame. But if you're the one asking for it to be delayed, then that forfeits your right to a speedy trial. You understand that?
I guess, yeah.
Yeah. I can't hold them to bring it to trial if you don't have a lawyer yet, and you want to get a lawyer, right?
Yeah,
Okay. How much time do you think you need to get a lawyer?
probably about 3 weeks.
Okay, that's March the 8th, so that's when we'll set the next hearing. March the 8th, the pretrial at 10 o'clock, and in case you still want to hire a lawyer.
All right.
Okay, next hearing, March 8th, 10 a.m.
State of Ohio versus Joseph Atkins, case number CRA 23-260, CRB 23-261, PRD 18-2412.
All right, Mr. Atkins is in custody here.
I believe so, Judge, yes.
I need to have him brought out.
Every time I see that, I make sure.
Goes back.
Get it ready. Just in case. Well, this is a different case. This is an OVI. I don't know if that's safe. So we need to make a file. I'll put it over here for later.
Mr. Smith, how do you wish to proceed?
Judge, he was in treatment, he left treatment, he'd like to go back in, is that correct, sir? He's right, he's got a problem he would like to address, I from the state's position.
I think, didn't he leave treatment though?
He did, where did he treatment?
Limbo.
Oh, that's right, they,
It was RRG.
RRG, yeah, because they had to just, they had a spot up there, but perfectly good.
Yeah, I really want to go back to that night.
There's nobody here from RRG. Do you have a West Virginia medical card, man?
I did. I just was still out of the way.
Well, I don't know, this, he kept it here for some reason, but, I mean, one of these is a felony.
You were going to dismiss the felony, I wasn't going to push the treatment.
Yeah, but you left treatment.
I
He's also got
had a choice, they told me to get out, me and my roommate.
23-356 also is still pending, that's a theft offense, misdemeanor theft from Walmart.
And I believe, Your Honor, 23-261 is a misdemeanor theft too.
Yes.
I think that it was a situation back, and this is clear back October of last fall, right? Was the last time he was before the court?
Yeah, actually, I think it was in September, he went to RRG inpatient, and I think he left there sometime in September.
Yes, scheduled for October 27th, but you get October, yes.
If we were going to consider keeping it here, we would want the 2 theft charges resolved immediately with a plea or to tell us there's going to be a trial.
We won't do that, Judge, on the 2 misdemeanors. Hopefully getting back on track with treatment.
I guess we'd also like to...
Probably you have to have an ankle monitor at this point.
Yes.
No objection, Judge.
We'd want to know where he's been since he left the treatment.
I was in Huntington, West Virginia, where I got from, and I was going to ProAct, so that's to do my treatment. I just didn't make it back here to court. And I mean, when I was arrested in Huntington, they had me on, they kept me on my Suboxone and stuff, and while I was there until all that charges actually got over here.
So I guess whether we would end up taking the case to the grand jury or not would depend on if he gets in treatment now, and we'd like to hear something from ProAct to see if he's gotten any treatment over there.
Yeah. Well, I would think that because he was inpatient before, I would think inpatient would be the way for him to go. Is there anyone he has a West Virginia medical card, but is there anyone that would be interested in getting that switched over?
His sister's in Chesapeake, so he says he gets switched to her at present.
No, I mean, he's on inpatient, so is he getting a monitor?
I'm sorry, yes, he's getting a monitor.
Yeah, I'll do it.
Okay, you want to do an assessment with him? You go ahead and do it?
Yeah.
Okay. All right, I'll order him released to Bethesda for inpatient treatment with an ankle monitor, so that'll have to happen before he can be released. We need to start that process with adult probation. Now, Mr. Atkins, this is really important. I have this speech, they've heard it countless times. They're sick of hearing it, but it's so important I feel like I have to tell you how serious this is, because I'm letting you go with an ankle monitor, which comes from the adult probation office, which is the same probation office that does the common police court, which you have a felony case, which normally would go on to the grand jury, you get indicted, then you go to the common police court for a trial. Well, we've kind of short-circuited that. You got a chance to go to treatment once, and that didn't work. You're getting a second chance, and a lot of people don't get a second chance. You're getting a second chance now with an ankle monitor, and that really ups the ante. And here's what you need to understand. Pay attention to what I'm telling you. So those ankle monitors cost about $2,000 from what I understand, paid for by adult probation. If you cut it off, they get really angry. They get really upset. Your case is going to go to the grand jury. You're going to get indicted. And that felony indictment warrant is good any place in the United States and almost every other country that has an extradition treaty with the United States. So there's no place to run and hide. I mean, eventually they're going to nab you. And then when they nab you and you come back to court, you won't be in front of me. You'll have a totally different judge. And you're going to have probation officers from common police standing there saying, this guy cut his ankle monitor off, we want you to throw the book at him. And you know what? They're going to throw the book at you. You'll go to prison for 3 years. How do I know that? At least 3 years. We have had some go longer. Because I've given this speech to people and they say, Judge, I would never do that. And you know what they do? They still cut their ankle monitor off and they go to prison. I've got people in prison right now that I've given this speech to, and they're that dumb that they still, I don't know if they don't believe me or they only think about, and I'll tell this story you've heard before. A guy wanted to go to a party in Charleston, so he cut his ankle monitor off, Charleston, West Virginia. He was out for about 2 weeks. He's now in prison. It's 2 weeks free in Charleston, West Virginia. Charleston, I love Charleston. I love the restaurants there. It's not worth going to prison for 3 years. Okay, and you're going to tell me you won't do that, right? Okay. even if you're tempted to, you need this, like, somebody stop me. I can't do this, I can't cut this ankle monitor off, because it's gonna be awful if I do. Mr. Beagle.
And our agreement on all this also would be contingent on us wrapping these theft cases up today.
And he said he'll do that, so he's entering a guilty plea to the 2 theft.
Yes.
We'd ask to delay sentencing on those.
Okay. I'll delay sentencing until you show me what you can do. So here's the worst case scenario I've already told you about. You go to prison for a long time if you really mess this up. The best case scenario is, you pled to 2 misdemeanor theft offenses. I'm not going to sentence you on those until we see what you do. You've got a felony, I believe it's a possession charge. So if you do really well in treatment and complete treatment, they're going to dismiss it. You go from maybe 3 years in prison to having that case dismissed. That's a stark contrast, isn't it? That's about as good as you can get your case dismissed and not have a felony on your record and get clean to boot. And then I'm going to give you, if you do that, I won't even give you any jail time on the theft offenses. You'll probably get some community service and pay a fine, and that's it. So the ball is in your court. Jail, and a lot of it, or possibly no jail. If you really do this, that's for your benefit, for you to get clean. Tell me about your family. Do you have kids?
I have 2 little boys.
How old are they?
One just turned 16 and the other one's 15.
Okay. Do you want to be around them?
Yes.
If you go to prison, you're not going to be around them. Truthfully, their attitudes are probably already formed at this point, 16 and 15. But I think you still have some influence with them, and you can show, hey, Dad turned things around, and that's something good to model for them. Okay. So that's, we think about cutting that ankle monitor off, think, well, this is really going to hurt my kids if I do this. And it will. Yeah. Okay, and I believe in redemption. I think you can always turn things around. You can't get down so low that you can't turn it around. But you got to do it this time. You need to do it for your sake and your families and everybody else's. The whole community is better when you're clean than when you're out there running around dirty. You understand that? Okay. Okay, so we want to come back and see how he's doing in March sometime. What's your schedule in March, Mr. Let's do the 8th. Okay, so I'm going to see you on the 8th. You'll be at Bethesda. You'll get a good report. You're doing what they ask you to do, when they ask you to do it, how they ask you to do it, okay? Unless they ask you to do something illegal or immoral, you got to do it, and I don't think they will. I haven't seen that out of them yet. So if you claim that, you're going to have a pretty high standard of proof to me. Okay? It's kind of like back old school with my mom. When I got in trouble at school, the best thing to do was not to go to my mom and complain about the teacher or the principal at school and say they treated me unfairly, because you know what? She wasn't going to believe me. I was going to get in trouble at home. It would have to be really strong evidence for her to turn and believe me over them. That's the same standard here. Okay? So, I'm not like, well, I won't say anymore. It's not like maybe it is today, where parents hop on their kid's side first before they even hear the teacher's side. So, we'll see you March the 8th with a good report.
State of Ohio versus Catherine B. Brown, case number CRA 2467.
This is Mr. Smith's case, preliminary hearing.
Mr. David, after speaking with Mr. Bill, I think we have a proposal to at least move this case forward to the council.
Okay, tell me about it.
The insurance board had OR block, she will wait for common police court.
Is she gonna do treatment?
No,
Okay. And does she need an ankle monitor, or you trust her to?
Oh, I don't think we need an ankle monitor on her.
Okay.
she had, she's watching the around, she's watching that court, she's going to assess it.
OBP?
Treatment.
Now, I don't know if this makes a difference, but she's charged with a felony too. High level felony. We still take her? Okay. OBP. Okay, so I'm going to change your bond from 10,000 cash or surety to 10,000 signature bond. I'm going to order you released to OVP for inpatient. She's waiving to the grand jury.
She is. Now, it's going to right as far as all the way to the police.
All right, and I would just say to you, Ms. Brown, the best thing you can possibly do for your case, I think Mr. Smith would concur with me, is to go to treatment and do really, really well and show up in common pleas with great reports, saying that you're doing what they ask you to do when they ask you to do it, how they ask you to do it, and that you're committed to getting clean and sober. That's going to help your case as much as anything possible. Okay, well, you're going to be in treatment here in Lawrence County with OVP, and they will accept your West Virginia medical card. Then you're going to go on to the other court for further handling.
Ohio recall panel settles. Case number TRC 23430. She is here.
Yeah, she's out here in the courtroom. It's one we've been waiting on.
Your Honor, I did talk to Ms. Pauls and Ms. Others did do a day of meeting.
All right.
This past Wednesday.
And are you paying anything on your fund today?
I just paid some this week. I paid $100. I'll pay some more next week.
You paid on the 13th, so that's good.
Yep.
Okay, March 22nd. March 22nd will be your next hearing at 9 a.m. It took a while to hear back from the dog town. That's why you've been sitting here all day.
Okay, thank you.
You're welcome.
State of Ohio versus Kerry Copley. Case number CRA 2466, A, B, and C.
Mr. Tyler Smith's case for preliminary hearing. Kerry Copley.
Mayor, I believe that as the defendant in this case, Ms. Copley agreed to waive the grand jury and her bond will be $35,000. That's something that she should be able to make.
Okay. And that's the only agreement, then there's no treatment component?
No.
So you understand you have a right to a probable cause hearing to decide if the state has enough evidence to take you to the grand jury. You're waiving that hearing, agreeing that your case will go on to the grand jury on our agreement to reduce your bond to $45,000 cash for sure. Is that, you understand that, Ms. Copley?
Yes, sir.
So I'll reduce the bond to $35,000 cash or surety. Case is waived to the grand jury. You need to stay in touch with Mr. Smith to know when you need to get before the common police court so you can keep your bond that you post. Because if they try to get all over and get you in the court and you don't show up, you might lose the bond and have to post a new one. Okay, the case is bound over to the grand jury. You're welcome.
State of Ohio versus Jeremy Daniels, case number CRA 17367.
Yes, sir.
Do we have a witness? Do we have if we don't have a witness, how do
All right, sir, you're Jeremy Daniels. This is an old case from 2017. It's alleged you didn't show up for a review hearing back in December of 17. Okay. You were ordered back then to do counseling with Prestera and pay court costs, and that was it. Did you get arrested in West Virginia then on this? How did you get here? How did you get in custody?
I got arrested over in Athalia.
Oh, Athalia?
Yeah.
Yeah, they're out. I drove up there the other day. They haven't had a policeman for quite a while, but if anybody drives through Athalia, you better slow down to 35, because they're out and about now. I saw them yesterday, I think it was. Didn't get me, but they got the car in front of me. So, how long you been in jail?
2 or 3 days.
Are you still living in Barbersville?
No, I'm living down about.
Guyana, okay. Okay. Valentine's Day, so 2 days, seems like 3, but it's been 2. So, I gave you a 90-day jail sentence back then, suspended 81 of it if you would go to treatment, but you didn't.
Yeah, I went to Lincoln, I
No. Are you still taking methadone?
Yes, sir.
The one in Huntington?
Yes, sir.
Every day?
Every day. 200 milligrams.
Wow, that's the most of anybody I've ever heard of. Usually, I mean, 100, 125, that's high. 200, I've never heard of anybody taking that much.
We got enough 200.
They just give you what you want, don't they? If you say, I need more, they'll give it to you. Do they ever, just so I'll know, and I think I do know the answer to this, the most counseling you get is they may say, Jeremy, how you feeling today? Is that about it?
No, yeah. All the reserves, counseling, pipeline,
And what do they talk to you about?
treatment stuff.
They never try to bring you down, right?
They're getting ready to leave yet.
Okay. How many years you been going there?
I just started back.
What were you doing before? Something
I went to the Lighthouse program.
rocky?
Yep, graduated.
Oh, this was filed as a felony and got reduced to a misdemeanor. State take any position on this?
No, Your Honor.
Okay. Well, here's what I'm gonna do. I'm gonna sentence you to time served. What were you doing in Athalia anyway?
I worked for Sport, delivering groceries for Walmart. And I was up there delivering groceries and they pulled me over for my siren being out.
You got a valid license
Yes,
and insurance?
yeah.
Okay. And you're taking 200 milligrams a day?
Oh, really?
I had a guy once on a third offense OVI that lived in Galquist and drove to Lincoln every day for 15 years to get methadone. And he got pulled over, couldn't do this field sobriety in, and he was only taking 125. And the only thing he tested for was methadone.
I work 14 hours a day.
That's scary. I mean, it's scary from, I'm out on a car, I'm out on a bicycle on the roads with somebody that's doing 200 milligrams
That's your
of
driving record.
methadone. Okay. I'll send you to time served. I assume you don't want to do 81 days in jail, do you? Okay. I'll send you to time served for not coming to your hearings before and not going to treatment like you were ordered to. And you had court costs to pay, which you didn't pay those either. So I'll give you another review hearing. So here's the thing. I'll be honest with you. This is a misdemeanor, so we're not going to come to West Virginia and extradite you if you don't show up. But if you come over here, like if Walmart sends you to Miller to deliver groceries or wherever you're going, because it was above Athalia, then you're subject to getting picked up because the warrant's going to be good in Ohio. So if you stay out of Ohio, you're good. If you come into Ohio, you're going to be subject to going back to jail. And I don't want to give you 81 days in jail. The jail's overcrowded now, isn't it?
Yeah.
I mean, we got 10 or 11 of just our people in there. So do what you're supposed to, stay out of jail. I'm going to encourage you to get on something other than methadone. Just, you know, I don't know if I'm supposed to do this, but from my observation, just sitting here all these years and watching, I don't see that methadone helps people. At least the clinics around here. There may be some place in the United States where they're using methadone appropriately and helping people with it, but I don't think in our area they are. And I'm talking about 2 clinics, one in Ashland and one in Huntington. And I think there's one in Wheelersburg. We rarely get anybody from there. Occasionally we have, but from my experience, they just hand it out like candy. Wherever you want, they give it to you. And I don't think the long-term effects, you taking it for years is not good. So anyway, I'm going to give you another review hearing March the 15th. So 1 month from today, you got to be back here, pay something on your fines, and come back and tell me about your treatment. Or just stay out of Ohio and never come back. Those are your 2 choices.
I'll come to court.
Okay, we'll see. Time will tell.
State of Ohio versus Jimmy Dement, case number TRC 213341, CRV 17331.
Sir, you're Jimmy Dement? Case number is 213341, 17331. It's alleged was that you failed to appear for a pretrial back in January of 2022, January 3rd.
I think that's when I had some,
This was Mr. Stratton's case. I know you probably don't remember. That Mr. Stratton was appointed to represent you.
yeah,
This was an OBI.
I had some death and back at that time.
He did go for an assessment at what was formerly known as Riverside Recovery. It's like Prince.
Yeah.
The artist formerly known as Riverside Recovery. I have a report from them in the file. I think he went back to Prince, didn't he? Or whatever.
Yeah, I think so.
And there's a case 17331, which is an old case, and it still is not resolved.
So did we resolve those cases?
I haven't resolved. So, at this point, probably should let you talk to him and then I'll decide the bond, so after you talk with him.
Your Honor, I guess
Do you
I'd
have
like...
input?
Well, I think it might be a good idea if he wanted to consider resolving this OVI case. It's a first offense, so we would not have an opposition to, and I don't know whether he needs to go back to treatment or not, but we would just be asking for nothing out of the ordinary as far as, and I don't know how many days he's been in jail since he was arrested. But you know, that would have an impact on what kind of bond we would want to have.
He also has, and that's not resolved either, unauthorized use of a motor vehicle from 2017. Shanna Cornell was the alleged owner.
Well, we don't have that file.
That's case number 17331. No new charges. You got picked up on warrants from both of these for failure to appear.
We could at least get court's file. So if you want to, we would be in agreement with an OR bond on the other charge, get him out of jail today if he were to plead to the OVI.
Okay.
We'll call you back out after you talk to your lawyer.
State of Ohio versus Cody Garrettson, case number CRA 2468.
This is Mr. Scott's case. It's set for preliminary hearing today.
That's correct. We've got to resolve. We're going to see how to discuss this on a clear with my client. We're interested in waiving the grand jury. Huge treatment. Here, his representative is willing to go to inpatient. Makes sure they know they have several fires in the back. Any of the resident of Ohio.
Do you have a medical card?
Yes, it is.
Ohio or West Virginia? Is there a request for an ankle monitor? Or?
No, I don't believe we would need an ankle monitor, Your Honor.
Okay. The complaint says actually homeless, Huntington, West Virginia. Who lives there? Who lives there?
My mother-in-law, brother-in-law, me,
What are their names?
Sherry and John.
I'm sorry, I didn't hear.
Sherry and John.
Last name?
Husband.
Husky?
Yeah.
Okay. Anybody, you want to spread the wealth anywhere or wealth around? Anybody else? No? Okay. Bethesda, you want to talk to him or are you willing? Okay. He's got aggravated trafficking charge.
He's going to call me.
Fentanyl. And, yeah, both charges involve fentanyl. Okay, so I'm gonna let him sign a $10,000 OR bond. He's waiving to the grand jury. You understand you're giving up the right to a probable cause hearing to this, for me to decide if the state has enough evidence to take your case to the grand jury. You're saying, I don't have to have that hearing. It can go on to the grand jury. Okay. In exchange for getting a signature bond. So, you'll be bound over to the grand jury. It behooves you. They haven't asked for treatment, but talk to Mr. Scott. He may say I'm an idiot, but here's what I would say if I was your lawyer, which I'm not. The best thing you can do is show up and common pleas and say, I'm a user, not a dealer. I'm getting clean. Look at what I'm doing to get clean. That's the best possible thing you can do.
So about the exact words that get only hearing to it.
So you need to start on that right away. Don't wait until the week before your hearing and then go to treatment, because that doesn't look like you're really in very good faith about doing this. Okay? Does that make sense? That doesn't guarantee you any particular result. I don't know. They may still hammer you because it's a pretty serious charge, but there's an awful lot of people that show up there that aren't doing well in treatment that maybe would get your space at the prison versus if you can show them that you're serious about getting clean and not doing this kind of stuff in the future. Okay, the case is bound over to the grand jury on a $10,000 OR bond. The other thing is you need to stay in touch with Mr. Scott so you can get you in to common pleas when they want you, because if you move or they don't know where you are, they may issue a warrant for you just because they can't find you, and then you lose a signature bond. This is about as good a bond as you can get. Oh, okay, and you're going to go, okay, he is going inpatient to Bethesda.
Yeah, I'm going to put him in today.
So he's to be released only to Bethesda. And as I said, do what they tell you to do when they tell you to do it. Okay, that's all.
The State of Ohio recalls Timmy DeMint. Case number is TRC 213341, CRB 17331.
Your Honor, I spoke with him. At this time, I'm going to plead guilty to the ODI as to excessive sentencing along with the pre-trial and the other charge. That's what I did last time.
Mr. Hill?
We are in favor of delaying the sentencing, and then we'll have an opportunity to look into that 2017 charge too and see where we stand on that. And we're okay with the OR bond in the meantime.
Okay, I'm going to add a condition to that. He has got to go to treatment. I mean, when this happened, he was in the truck, passed out, and they narked him. And he was ordered to get a treatment before.
And I believe that was 7 years ago. What year was it?
2021.
2021.
November 2021.
I was thinking it was December. I'm sorry. I don't think anything's wrong with that, Your Honor.
Okay, how do you pay for medical services?
Medical, yeah, carefully.
You were at Riverside Recovery, now it's RRS, and I got a report from them December 28, 21. He then was in intensive outpatient. He was non-compliant the first week. You want to do an assessment with him? And
Yeah, I'll do an assessment.
I'm going to have you talk to Mr. Gwynn, and then we'll come back and decide exactly what we're going to do in your treatment. We'll recall that.
State of Ohio versus Jeffrey A. Leffingwell, case number CRA 2469, CRB 2470.
This is Mr. Smith's case, right? Preliminary hearing and pre-trial.
Judge, I discussed how I did authorize the states to reduce bond to an overall bond, but we have no objection to that. We're going to have to go to the grand jury. And I'm assuming that misdemeanor as well will go with it.
Yeah, we would nolly the misdemeanor.
Misdemeanor is 2470. He nollied to grand jury. He's waiving his right to probable cause hearing in this court on 2469, having a weapon under disability.
Yes, sir.
You agree with that, sir?
Yes, sir.
Okay, so we need to sign a waiver.
Did he say there was an OR bond?
I'm going to set it. It hasn't been an OR bond set yet. He's had a cash or surety bond. I'll set it to 10,000 OR. So same thing I said to the previous gentleman, you got as good a bond as you can get to keep it, make sure the court knows where you are, your lawyer knows where you are to get you into court in Ironton when, after the indictment is returned.
Absolutely, yeah.
Okay, I'll accept your waiver. Allowed to sign a signature bond. It's going to go to the grand jury, be an indictment, and then you'll be ordered to appear at the courthouse in Ironton for the common police court. Make sure, if it was me, you have a computer. I would check every day the clerk's website to see if my case has been returned, so I get there when they want me there. Because if you don't show up, they're going to issue a warrant for you.
It's been many years now.
And then you will have to post another bond. You haven't posted one. You'd have to post a bond. Okay, next, case is bound over the grand jury. You're right.
State of Ohio versus Jerry G. Morrison, case number CRB 2453, A, B, and C.
Jerry Morrison. Okay, this was set today for sentencing. You're Jerry Morrison?
Yes.
I just want to go over this and make sure I understand this correctly. You have a charge 2453A is aggravated menacing. It involves Irvin Ray White Jr. that you caused him to believe you caused serious physical harm to his personal property. And you entered a guilty plea to that? No contest? And no contest means you don't want to fight the charge and you're agreeing you to be found guilty if I think what the state says it has as evidence is enough to convict you. Is that what you want to do?
Yes, sir.
Okay, and you're sure about that? These are serious charges. Then you've got a resisting arrest charge, 2453B. It's alleged February 1st that you recklessly interfered with the lawful arrest of yourself. That's a second-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. How do you plead to that? Okay. And then 2453C is disorderly conduct. Same date and time. The state's alleging you were voluntarily intoxicated and in the presence of other persons engaged in conduct that was offensive or caused them to be annoyed or alarmed by your conduct. How do you plead to that? Okay.
There was a note on the file that the prosecutor intended to file an additional charge.
We don't have anything additional.
Okay. All right, so does the prosecutor have a recommended sentence they want for Mr. Morrison on this? He's been in jail since, I guess, since this happened. I think the plea was entered on the 2nd.
The state's recommendation would be 60 days in jail with credit for the time that he served and suspend the balance. They also are going to ask for a no contact order.
He was booked on February 1st, Your Honor.
Okay, so he's got 15 days in.
We want a period of probation. We don't take any position on fines or anything else.
All right, Mr. Morrison, you have a right to make a statement to the court before I sentence you. Do you have anything you want to say?
Yes, sir.
Go ahead.
I'd like to say that I was operating that day in a blackout. I really don't remember much of it.
So you were drunk, in other words?
Yes, sir.
Okay.
Yes, sir. And I'd really like to apologize to the people.
Who were these people that are involved?
They're neighbors that live across the street.
Oh, they're neighbors of yours?
Yes, sir.
Okay.
And I'd like to apologize to my wife.
Is she here today?
Yes, sir.
Okay.
And I know I have a problem with alcohol, and I seriously want to address the issue.
Okay, well, that's good.
She's made it known to me that it's either going to be me or the alcohol, and I don't know what is the real.
Okay. And is Mrs. Morrison here today? All right, ma'am, I'll let you make a statement if you want. Is there anything you want to tell me before I sentence him?
I love you.
Okay, well, that's good. We all need love. We all need somebody that cares about us. So you're ahead right there. So you haven't done enough to destroy that yet. So I take it from what he said, and I think I was watching, you agree with him he needs to fix his alcohol problem?
Yes, sir.
Okay. And you'll support him in doing that?
Yes, sir.
How do you pay for medical services, Mr. Morrison? You have a Medicare?
I'm on Medicare, yes, sir.
And Medicaid? You have Medicaid also? And you live in Chesapeake?
Yes, sir.
At, what's Township Road 1095?
Pardon?
Township Road 1095, where is that? That's your address, right?
It's Rodney Avenue.
Okay, is that right in town, right in the city limits?
It's
Well, probably RRS would be a good fit for you. They're right down the street here. Are you from Chesapeake originally?
Originally from Huntington, West Virginia, but I've lived over here for quite a while.
Okay, well, this will test how long you've been here. Do you remember where the trade well was? Mr. Morford knows where the trade well was in Chesapeake.
My dad had a patient there that was a butcher, and he always came home with the biggest steak.
Well, that's where RRS is now, where the old trade well was. It's across from Chesapeake Plaza. So I'm going to order that you go there for some counseling for your alcoholism. Yeah, I'm going to have, I want you to speak to Mr. Quinn. He's here from that agency before you leave today. So I'll have him come back and talk to you and get something set up for you to come in there and start your counseling. And so, how old are you, Mr. Morrison?
66.
You're 2 years younger than me. Maybe 3, because I'm going to be 69 shortly in May. So, yeah, I remember when the trade well was there. My parents used to shop there. Okay. On the aggravated menacing, well, what's your income? You get Social Security, is that it?
Social Security, I have to draw pension also, so
From where?
elevator construction. It's about $1,000 a month,
Okay. How much is your Social Security?
about $1,300 a month.
Okay, I'll impose a $150 fine on the menacing plus court costs. 60 days in jail, suspend 45, give you credit for 15 you've already served. So you'll get out of jail today. Stay away from your neighbors unless they come back to court and say, we don't care if you come around again, because I'm going to put in a no contact order. Okay, you don't think they will? Well, maybe if you change your ways and get clean and apologize to them, they might forgive you. And you can heal that rupture that you got with them. That would be good too, but I'm not going to worry you to do that, but I think that would be a good thing for you to do. Just apologize and tell them it was my fault. I'm going to address the problem. I'll set a review hearing for you for April 1st. So you're going to come back here April the 1st at 9 a.m. and I'm going to look whether you have been going to your counseling sessions. They'll be here and they'll give me a report whether you're doing it or not. Okay.
Is that 2 years probation, Your Honor?
2 years of probation.
So we've got this no contact order for him to sign. And I think we tend to agree, although I was under the impression that he pled no contest back on February 2nd.
He did. I was just going, because he didn't have counsel, I wanted to make sure that he was knowing.
We'd let the victims know that they could come today, and they declined to, but they asked for the no contact order.
Okay.
And so
that's fine.
They took no position on anything else.
Okay. Then he had a resisting arrest. I'll impose a $100 fine on that. No court costs.
Disorderly, Your Honor.
$25 on disorderly conduct. So Mr. Gwynn's going to come back and talk to you back there, and you'll go back to jail. Then he'll get released from the jail later. You don't have to pick him up if you don't want to, but you can pick him up at the jail here in a couple hours probably. He can't stay at the jail. They're going to kick him out, right? You don't have to take him back home if you don't want him, but he can't stay at the jail. Okay. April 1st is your next hearing here. That's all.
State of Ohio versus Jacob Price, case number CRE 2475.
Sir, are you Jacob Price? Mr. Price, it's alleged that there's a warrant for you in another state, and that state is North Carolina. So you have rights in extradition hearing. It's a hearing not to decide, they're saying you violated some sort of probation you had in North Carolina. So if we have the extradition, that won't be the issue that I'll decide. The issue before me will be, do they have good cause to send you to North Carolina? And you can have a lawyer here, you can have a hearing here, and it will be solely on that issue. You can waive extradition, that just means you voluntarily agreed to go to North Carolina. Then I'll give them a time period in which to come pick you up, and That moves it down there, and then they'll have a hearing about whether you did or didn't violate your probation. So do you understand the proceeding that's happening here?
Yes, sir.
And do you want to have an extradition hearing? Do you want a lawyer appointed here to represent you on extradition?
Mr. Smith was here, I'm not sure where he's at.
Is he representing on other issues?
No.
So let's get him out here.
Mr. Smith.
So you've had a case in
Roger Smith.
common pleas too here? Why don't you get him here, whisper to him first, because what you tell him
Yes.
is not, can't be used against you, but what you tell me on the open record can be used against you.
I didn't hear the call. We spoke, he's got, in North Carolina, I believe, has an extradition. He's due to get off parole March 5th. We have a hearing from Judge Bauer on the 6th that should clear up.
Do you want to come back after
If
that?
we could, 8th, Judge,
Yes.
he should be able to go to Shine, and he's already assessed it, admitted or excessive. It's just this kind of, but, you know, it's.
See, he's going to go to Shawnee now? Or
No, well, he's all, well.
He wants to.
He wants to, but he's not
Got
off
this whole-
parole until the 5th of March. So once you're off parole, then that takes care of.
Oh, parole from North Carolina?
Yes, and then March 6th, next year, we're going to Judge Ballard, who was
I
already.
mean, are they going to lift the holder or not?
That's all in contact. Tell
Okay.
them what we're doing up here.
All right, so we'll come back here March 8th for another hearing, 10 o'clock.
Yes.
Okay.
State of Ohio versus Jason Turner, case number CRA 23638, PRD 231050, A and B.
Jason Turner. This was Roger Smith's case. 23638. He had a preliminary hearing according to this on December 1st that he didn't appear for. He had been at RRS for treatment. There's been a warrant outstanding. Do you need to talk, have you talked with him?
I did not, Judge. I'm hoping he can get back to treatment, just show us what to see if he wants to just take it to grand jury or hopefully I can give him another chance.
Let's let you talk and then
Yeah, so
call back.
Judge, he's telling me something I didn't talk.
I'll just say this, I looked at his prior results and he tested pretty consistently for fentanyl, so that tells me I'd be strongly considering inpatient with probably an ankle monitor if he's going to stay here, or he can go on to your injury. So this case will be recalled. You want to file? Yes.
State of Ohio recalls Timmy DeVent, case number TRC 213341 and CRB 17331.
Okay, he was going to meet with Mr. Gwynn.
Yes. Your Honor, I requested a drug screen.
Have you done a drug screen yet? Okay. Well, we'll wait. Okay, for what? So you're willing to go to inpatient then? You're willing to go to inpatient?
He requested outpatient, Your Honor, but I asked about his use and he just said, yeah. So that's why I requested a drug screen.
Yeah, you need inpatient and everyone's kind of hard to get these days around here. isn't it? Well, we don't see it in court as much as we used to. Put it that way. I don't know. I'm not speaking from experience, but the guys don't see it in court like they did at one point. So, he's pled to the OVI, going to delay sentencing. He's going to go to inpatient treatment with RRS. He still has this unauthorized use, which is pending. State's going to check with it's been a while, claim party, what she wants to do. And we'll come back, I think we've already hit March 8th. Friday.
Yeah.
March the 8th will be his next hearing for sentencing on the ODI and pretrial on 17-331. You're welcome. You're welcome. Do what they tell you to in treatment. Get a good report.
State of Ohio versus Chastity Seckman here in court, Your Honor. It's Tyler Smith's case. Case number is CRA 23688, CRB 23689.
Pretrial and preliminary hearing.
Your Honor, I believe we were just here a couple weeks ago. She's now an inpatient OBP.
And the report looks like. That's a good report. Second.
It's been hard.
Continue to monitor and come back. She's going to go from inpatient to outpatient stay with OVP outpatient.
Yes.
Keep the case here. March 15th.
What was the date, Your Honor?
March 15th. Is that good?
Is that a Friday, Your Honor?
Friday.
Yes, that's fine.
March the 15th will be the next hearing for pretrial and preliminary hearing, 10 o'clock.
Thank you.
Thank you, Your Honor.
Keep up the good work, ma'am.
What time was it?
10 a.m.
State of Ohio versus Stephen Thompson, case number CRA 19235, CRA 22617, CRC 222476, A, B, and C.
It's Mr. Morford's case. Mr. Thompson's at RRS.
We get, probably you will on Mondays instead of Friday. You want to do the future? Yeah, yeah. Yeah, Mondays are better. Why you down talking? I'm trying to get that's overrated. I mean, I've been there since 5 this morning. Yeah, I'm supposed to be there tonight. Well, I have it.
Yeah, you pled guilty to an ODI some time ago, we've just been delaying sentencing while he's been going to sentencing. And he's got, I think it's a possession that's still pending. So how do you want to go forward?
Well, I mean, if I read this correctly, he still has some work maybe he can do.
Yes.
I'm sure he's hopefully proud of his own progress. I bet his mom would be
Absolutely.
pleased.
He's came very far.
And we want to see it through to the finish line. So we'd be okay with another continuance.
Okay, let's go a couple months then.
Just to refresh your memory, he's also with Judge Finley and ILC.
Okay.
Yes. I think I can complete that next month.
And when you pick next review date, could you move it to a Monday? It would be better with his work schedule if you could do that.
April 15th? Does that work?
Work here, Judge.
Okay. Next hearing is April 15, 10 o'clock.
Thank you, Your Honor.
Thank you. Thank you, Your Honor.
State of Ohio versus Gregory Wiley, case number CRA 20-624.
And he was not here on the 9th, but he was compliant according to the report, so it was continued to today.
He is no longer compliant, and we
Okay.
have not been able to reach him, so we're not sure where he is.
All right, well, this is a felony, so how does the state want to handle this?
We'll go ahead and nolly it to the grand jury.
And it's failed to appear he's not compliant with treatment, it's going to be knowledge and reading.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. We have sentencings now.
State of Ohio versus Kenneth Roberts, case number CRB 23-142.
May I approach, Your Honor?
Yes, Mr. Stratton's case.
So May 17th is, that's my graduation, so I don't know why.
Is it sober living at hometown recovery?
Yes.
Projected graduation in May.
Yes.
Good drug screens.
Yep, all negative.
Yes. Good report.
Thank you.
Let's go. Do you want to see completion for sentence?
Yes, Your Honor, and the victim in this also wants to be present, and we've let her know that we make sure for her to be here the last, what's going to end up being the sentencing hearing. So I don't know whether that's the next hearing or not.
Well, I think with the reports he's been getting, why don't we just set it, that is, the 17th is a court date, so we can set it that day, May 17th, if that's, works for you, Mr. Stratton.
Just a second, there is a,
May 17th.
just one second, I know there was a trial I had scheduled in May, it's not, is that a Friday? That should be
That
good.
is a Friday.
Yeah, that should be good.
All right, next hearing, May 17, we'll look to conclude it then.
Just one, I think he has something he wants to say.
Yes.
Talk to you.
Can you talk about,
Can you talk to him?
about the
License.
about the license and have you guys been working on that?
I'm going down and get him today.
Oh, okay. So, Judge Capper, his counselor had spoke with me about him getting his license back. He said he's going down to get them today. And then he has a couple other things to complete, and then we were okay with him moving to outpatient services then.
Okay, whatever you recommend, I'm okay with it.
Awesome.
He's gonna not complete treatment until May 17th, though, is that right?
Correct.
Okay. Yeah, I'm on board with whatever you think. It's recommended by the professionals, so. Let's keep the May 17th day.
Thank you, Your Honor.
Good luck, sir.
Thank you.
State of Ohio versus Nicholas Adams, case number TRD 201480.
Nicholas Adams is here. Set for sentencing. Well, set for sentencing because you have a bond up. So, do you have a payment on your funds?
I'm just gonna pay today after
Pay it
court.
off, or
No, sir, no, sir.
how much are you paying?
25.
Okay. And then you still have 2 days of community service to do?
Yes, sir.
Okay, when are you gonna get that?
I was going to talk to him today to get it done next week, like Wednesday and Thursday.
This is the gentleman you need to talk to. So I'm putting you down for 25, go to the clerk, pay, talk to Mr. Cooper about your community service, let's get this wrapped up.
Yes, sir.
And I need to give him another date.
I don't have a date
Okay, March 15th will be your next date. If you get it finished by then, you don't have to come back.
Yes, sir.
Or, and that's the sentencing. March 15th at 10 o'clock for sentencing.
State of Ohio recalls Jason Turner, case number CRA 23638, PRD 23250A and B. I can hold them.
Is the DUS from the same time as the... This was,
Okay, Mr. Smith, take some time to talk with Mr. Turner, and now we're back on record.
I did, Judge. He is, wants to proceed to the grand jury. I explained to him what felony means, and we had a good conversation. I think it's because of the style of the GGA, so that 5.
One thing I'm worried about, though, is if there are drug issues that need to be dealt with in the meantime, and I prefer to have him waive for an OR bond and agree to go to treatment in the meantime.
Well, if it's outpatient, he doesn't, that's why I just want to keep it from the outpatient.
Well, I mean, if he wants to go to grand jury, then that we'll agree to do that. And if they recommend outpatient or say that he can do outpatient, we wouldn't oppose that.
I think he needs inpatient.
Well,
I think he's a big risk if you let him back out on the street because he's testing for fentanyl. The last report I had said he was positive for fentanyl.
we would not be in a position to have a preliminary hearing today, but we could, in short order, if the court set a bond.
Well, when did he come in to, he just got arrested.
I didn't know those.
So you don't have to have it today, because he missed a preliminary hearing back in December.
Well, yeah, I'm speaking of, we can have one within the next week.
Here,
Friday, Tuesday, I've got
when did he come into custody?
Booking is, the date is the 16th, it was real early.
Oh, today?
Yeah.
Okay, we'll have it on the 26th then.
If he,
I'm here then, that's good.
if he would agree to go to residential treatment with an ankle monitor and waive to the grand jury, or stay here, we would be agreeable to that, either one of those.
You want to talk further or privately? Yes.
I would like to.
So I'm probably going to send him to RRS inpatient if he stays here.
State of Ohio versus Brittany Nicole Kraft, case number TRD 163493.
This is on the sentencing docket for today. There's a bond up. That's the reason. And you're trying to get your license.
Yes. I
How's
just
that
need
going?
a little bit more time to finish paying it off. I should be able to pay it off by the end of March. Everything paid off and have everything back.
You want to come back April 1st?
That would be great.
At your request, the case is continued to April 1st for sentencing at 10 o'clock.
10?
Yes, ma'am.
Is that it?
Yes.
Thank you.
State of Ohio versus John Riggs, case number CRB 23528. John Riggs.
Set for sentencing today. It has a bond up.
Oh, sorry.
He was going to Ramey East Step facility.
Yes, he was supposed to have completed our 30-day inpatient program and continued there. However, he ended up leaving AMA from our program about 3 days before he was supposed to complete and go there. I explained to him that, you know, we definitely suggested against it, and he had told me that he was just going to show up down here and explain to you that he needed to go home first and all this other stuff. So we haven't heard from him since, and I do not believe he continued to where he was supposed to.
Your Honor, I've been contacted by his probation officer in Kentucky, and he's not abiding by their rules over there, and they're looking for him.
Okay, so I'll issue a warrant from here also. Thank you.
Thank you, Your
Honor. The bench warrant for failure to feed.
State of Ohio versus Brittany L. Smith, case number TRD 22673, A and B.
Brittany Smith is set for sentencing. And this is, she was at Bethesda one time.
I guess we thought this was a different Brittany Smith, because she is scheduled to be here on the 16th too.
Okay.
She's there, she's compliant.
Brittany L. Smith, I wonder with, date of birth September 8th, 89. Does that make sense?
She's trying to get her license back.
Yeah. So I think it's a different one?
It is a different one.
Okay. There is a report from Bethesda in the file.
Monitor today.
And it's just the wrong Brittany Smith file. And let's see if there is a bond. I don't see a bond on this. Oh, on that? Okay, let's recall that. You're right.
Okay, I found the bond in there.
On John Riggs, he actually has a bond, so we'll issue a warrant, but I'll set a bond forfeiture for March 15th for Mr. Sowers, and I'll notify him. Tell the truth, this guy had one of the worst drug screens I've ever seen. Okay, bond forfeiture hearing on John Briggs, March 15th, 10 o'clock. And back to Brittany Smith. She's supposed to show up to give proof of insurance. But I don't see, I think it was set for sentencing just because she's trying to get reinstated. I don't think she had a bond other than an OR bond, so the benchmark for failure here.
State of Ohio recalls Jason Turner, case number CRA 23-638, PRD 23-1050, A and B.
Judge given the option to sit in the county jail until the 26th, he indicates he is willing, if the state still willing to keep it here, to be released to RRS today on a GPS monitor.
I think that's a smart play. If you're going to take this seriously, you need to take it seriously and get clean and, you know, I understand you have some family that's affected by your situation. Is that right? So I'll order you released to RRS with an ankle monitor, so we need to start the process of getting an ankle monitor replaced. And then let's keep that date for him to come back and we'll get a report. You're here that day. So February 26th, I'll see you hopefully with a good report that you're in treatment and doing well.
Thanks, Judge.
We'll finish with the inmates.
So that finishes up at the jail. Thank you very much.
I think he's good.
State of Ohio versus Wendell K. Freeman, case number TRD 24199. This is set for trial.
Okay, this is a case set for trial today on a traffic matter, 24199.
Your Honor.
You're, I assume, Mr. Freeman, right?
Yes, Your Honor, I don't have my hearing aids. I can't hear very well, so.
God will do the best we can to get you here. I'm going to tell everybody to speak up. Is the state ready to proceed, or how do you want to handle this, Mr. Hill?
Oh, well, we do have a trooper here. I didn't know that he'd been subpoenaed or knew to be here, but he is here, and so we are ready to proceed.
All right, Mr. Freeman, Mr. Cooper, would you help Mr. Freeman get a chair pulled up here? And this is Trooper Barnett, I believe. Yes, sir. Raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. You may have a seat there, and if you could speak up, Mr. Freeman is hard of hearing, so we'll try to speak at a volume where he can hear things. You can go ahead, Mr. Jones.
Thank you, Your Honor. Trooper, how are you today?
I'm doing all right, sir. How are you?
I'm good. I'm glad you're here. Can you state your name and where you were employed?
My name is Trooper Charles C. Barnett. I work for the highest highway patrol and stationed at the Iron Temples.
Were you on duty on January the 22nd, 2024 at about 3:28 in the afternoon? And at that time, did you have occasion to come into contact with Wendell Kent Freeman?
Correct, yes.
Can you explain what the circumstances are, starting with where you were and why you were there?
Okay, so I was doing routine patrol on US 52. My dispatch, they dispatched me to a non-injury crash, a vehicle in a ditch on County Road 1. I'm right, it probably been a mile off 52 towards the west entrance of County Road 1.
Is that in Perry Township?
Yes, that is Perry Township.
And what did you find when you got there?
I arrived on the scene and observed Mr. Freeman's vehicle in a ditch, and it had damage to the rear of it from the impact with it.
Do you recognize Mr. Freeman in the courtroom? And if you do, can you point him out, please?
Yes.
Record will show you pointed to the defendant.
Were you able to determine what caused his vehicle to end up in the ditch?
When I walked through the scene, it looked like he drove off the right side of the roadway, and his vehicle spun as in the ditch, and that's why he ended up facing eastbound when he struck the embankment on the ditch.
Did he strike any other vehicles or cause any harm to anyone or anybody else's property?
The property, it was just been that ditch that's the only damage that was done, and to his vehicle.
The ditch, like, was there something of value in the ditch?
No.
Was Mr. Freeman there at the scene?
He was.
Did you investigate to make sure that he wasn't impaired in some way?
From what I observed talking to him at the scene, I did not see any signs of impairment at that time.
Okay. Were there any other aggravating circumstances about this other than he drove off the road and?
No, it just looked like the roads were wet at the time. It was right after we got that big snow, and that's where they was going through plowing, and the roads were wet. There was a little bit of slush at the time.
That's all I have, Your Honor.
All right, Mr. Freeman, do you want to ask the trooper any questions?
Yes, sir.
Go ahead.
Trooper
Barnett.
What is it that made you determine that the charge is lost control of the vehicle, failure to control?
Correct.
What made you determine I didn't control the vehicle?
You ended up in a ditch.
I was in the ditch.
Correct.
That's the only investigation you did to determine that?
The other vehicles that drove by did not end up in the ditch, so therefore you lost control of your vehicle, you drove off the right side of the roadway, you spun out, and then your rear end hit the embankment on the ditch.
Was there any evidence that you've collected that showed that I lost control?
You drove off the right side of the roadway.
Okay, that's the only evidence?
Did you do it intentionally?
Did Mr. Freeman say at that time that there was a problem with the vehicle?
There was no evidence that I found with the vehicle that could provide that it was not broke at the time prior to the crash, or was it broke during the impact with the ditch.
So you didn't check for any evidence to see if there was any problem with the vehicle?
I had the tow truck drivers on scene look under the vehicle. They said nothing looked broke or where it shouldn't have been.
Could you speak up and say that again, please?
I had the tow truck drivers at the scene check under the vehicle when they was pulling it out of the ditch, and they said nothing looked broke under the vehicle that shouldn't have been.
Did they check all four sides of the vehicle, sir?
I'm not clear. I'm not sure on that.
If I recall at the time, Mr. Freeman asked you a question if they checked all four sides of the vehicle. Is that correct?
I don't recall.
Okay, do you recall Mr. Freeman saying that they didn't check one side of the vehicle, one tire?
I don't recall.
Okay. The skid marks indicate to you that what happened?
That you hit your brakes, drove off the right side of the roadway, and struck a ditch.
Usually when somebody loses track of the vehicle in your expertise, is there more than one skid mark?
It depends. All crashes are different. Some people veer off the right side of the roadway, or they swerve to miss an animal or something in the roadway.
How many skid marks did you recall being on the road?
There was, on the right side, there was one tire mark all the way down. There was no skid marks on the roadway, which with the roads being wet would be hard to see at that time as well.
the roadway you say was wet?
Correct.
Was it partially dry?
You could say that.
Sir?
Yes, you could say it was partially dry.
Okay, so the skid mark that you seen was from how many tires?
It was in the snow. There was no skid mark on the roadway.
I'm sorry, can
There was
you?
no skid mark in the roadway. The mark that I measured was in the snow on the right side of the roadway.
Can I show you exhibit?
You can show, you got a picture on your phone you want to show him?
Sir?
You have a picture on your phone you want to show him?
Yes, sir.
Okay, I'll let you do that. We have the Dale show it to him.
I did not see that when I was at the scene.
You did not see that skid mark? How many skid marks do you see in that picture?
From what I saw was one.
Okay, so from your conclusion, from only one skid mark, how many tires would it take to only show one skid mark?
One tire.
And it's the one tire that was unable to be seen in the ditch, correct?
You can say.
Correct?
You can say it, correct.
Okay, so therefore, without checking that tire to determine whether there was a malfunction on that tire, you can't make a determination that.
I couldn't make a determination either way. I'm not a mechanic. Nor.
What do you call this? What do you call this skid mark?
If I would have saw that on the scene, it was up here, you would have locked your brakes up to try to avoid something.
But from only one tire that wasn't checked. Is that correct?
Like I said, that even if I did check it, I'm not a mechanic, so I would
Okay.
not be able to provide that information.
Okay.
Nor were the tow truck drivers mechanics as well.
All right, that brings me to the next question. What is a tow truck driver, is he qualified to make an assessment that there was no mechanical cause for the vehicle to wreck other than just him being a tow truck driver? Is he an expert, would you consider?
Like I said, he's not a mechanic, nor am I.
Can I show you further evidence?
He doesn't get to make those decisions, sir. That's a decision I make. So what is it you're wanting to offer?
What do you say?
What is it that you're offering, sir? What is that?
I researched on the internet, and these vehicles have a history of rusting in that area, and I was going to present this. I also
Unless he
went
agrees
to,
to it, that's not going to come in. Mr. Hill, what's your position?
Well, I'd like to at least look at it, but I would tend to think that it's something that we would object to. Yeah. We would not agree to the admission of that.
Okay.
What was that, sir?
You're objecting, so I'm going to sustain the objection. You can't just bring something off the internet and present it as evidence. So sustain. It's not.
Can I show you further evidence, Your Honor?
What is it?
It is where the vehicle, a picture of the vehicle when they towed it in to show that
You can show it to the witness.
the frame was broken.
Let the bailiff show it to the witness. We'll show it to Mr. Hill first. Any objection to it?
To it being admitted? Well,
Well, it's not admitted, but being shown.
Oh, no, we don't object to it being shown.
Okay, you can ask questions about it, I've seen it. Do you have questions you want to ask the trooper about it?
The question is, did you inspect this
Like
side
I
of the
said,
vehicle?
I'm not a mechanic, so I cannot provide a mechanical assessment on a vehicle. And where it was crashed, the frame could have broke once it made impact with the embankment in the ditch, or once you struck the ditch, it could have broke then.
So, you're not a mechanic, however, you can tell that this picture shows a cracked frame.
Yes, was that picture taken prior to the crash or after the crash?
It was taken after the crash. I mean, I couldn't take it before the crash, it wasn't broke.
How do we know that the frame did not break during the impact with the ditch?
Well, I mean, excuse me, if you had a vehicle that had a broke frame, would it be drivable?
That'd be an unsafe vehicle.
Sir?
It would be an unsafe vehicle.
Okay, so it wouldn't be drivable if it was broke, is that correct?
It would not. No, sir.
Okay, did Mr. Freeman tell you anything about stopping prior to his interaction with you?
I don't really recall the interaction, but I believe you did. I think so.
Do you not recall Mr. Freeman telling you that he had stopped just prior at the volunteer fire department in Sheridan and told them, and said that he had a little wobble that he felt, so he pulled over to check it? Do you recall that?
I do recall that, yes.
You do?
Yes.
Okay, so Mr. Freeman showing that level of responsibility to check a wobble in his vehicle shows that he was concerned with the problem. Is that correct? Would that be a correct assessment?
Correct.
Okay, so is it not more probable with the evidence of one tire mark on the road and the tire being bent from your pictures that I'm sure you have?
Yes, I remember the tire.
Would it not be reasonable to call that a malfunction from the vehicle instead of losing control?
If you determine that there was a malfunction on your vehicle, you still continue to drive an unsafe vehicle down the roadway, and then you cannot control it.
I really apologize for that.
You determined that your vehicle had a malfunction after you stopped and checked it, and then you continue to drive an unsafe vehicle down the roadway, and then you lost control of that said vehicle and crashed into a ditch.
Well, I had a wobble. It doesn't make that an unsafe vehicle. Sometimes the car, I'm driving a car today that's got a wobble, but it's got a bump on the tire. It's not bad, it's just very slight. But if I stopped to check the vehicle, if I would have found it unsafe, would it be reasonable do I not seem like a reasonable person that would take off on a vehicle that was unsafe?
I don't know you personally, so I'm not sure if you would or not.
Okay, so the bottom line is, you're not 100% sure that I lost control of the vehicle. Is that correct?
I am sure that you failed to control your vehicle. I am sure you failed to control your vehicle.
A malfunction is failure to control?
Can you prove the malfunction?
Sir?
Have you proven the malfunction?
I showed you pictures, did they not?
After the crash.
Shield, are you ever gonna?
Well, I can't show you
I'm
pictures
sorry.
before the crush. How can I show pictures
I was
before the
somewhat
crash?
entertained by it, actually, and I apologize.
Okay, I'm gonna consider that an objection. This is argumentative, it's not questions. If you have questions, you can ask questions. We're not gonna have argument.
Oh, I'm trying to show the facts here. I mean, if he
I've
didn't.
given you your direction. Ask questions.
Okay, I'm trying, I'm sorry, Your Honor. When a vehicle has a recall, and the recall the person that had the recall hadn't had time to fix the vehicle, and they didn't know that it was going to break down, and it did break and caused them to have an accident, is that a cause for them being guilty of failure to control?
Not unclear. I'm unsure.
You're
Unsure.
You assume?
Unsure.
Unsure? So therefore, you would be unsure about this vehicle?
Is there an objection? What's this gonna go on forever if you don't start objecting?
Yeah, okay, I object.
Sustained. There's no evidence that this vehicle was recalled, so I sustain the objection to your question.
Excuse me, sir?
I sustain the objection to your question. Go to another question.
Oh. Do you bring any evidence to show that that Mr. Freeman lost control of the vehicle?
It's in the crash.
I'm going to object.
Sustained. Asked and answered. Next question.
So I think I'm trying, what I'm trying to ask the question is, are you 100% sure that Mr. Freeman lost control of the vehicle based on
Objection, Your Honor.
the pictures that you've seen?
You've already asked him that. He's
Well, I
answered
didn't-
that question.
I didn't-
Next question.
I have no further questions.
Any further questions from you, Mr. Hill?
Trooper, is a motorist responsible for making sure that they're driving an automobile that is safe to be on the roadway?
Yes.
That's all I have, Your Honor.
Anything further, Mr. Freeman?
Do mechanical failures happen?
Objection, Your Honor.
Well, wait till he gets the question out.
Well,
Do mechanical failures happen without the knowledge of the vehicle owner? Just happen?
Objection, Your Honor.
Sustained. There's already, well, I'll allow him to answer that question. It's very theoretical, but go ahead and answer it if you can.
Yes.
Could this vehicle have just had a malfunction on its own? With
That objection, he's already answered that question. It's already been asked of him.
We have gone into that, so I'll sustain it. We don't need to plow that ground again. I sustain the objection.
I can't ask a question.
Right.
Okay.
You've already asked it in essence.
I guess there's no further questions.
The trooper may step down. Thank you, trooper. See discharged.
Yes, thank you.
Thank you for being here. Do you have any other witnesses?
No, Your Honor.
All right, Mr. Freeman, do you wish to testify or call a witness on your behalf?
I have no one to call at this time.
Are you going to testify yourself?
Yes, sir.
Okay, come up to the stand, I'll swear you in. Raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
You may be seated. State your name for the record, and then tell me what you want me to know about this incident that happened on January 22nd, 2024.
Yes, sir.
State your name first.
Wendell Kent Freeman.
Tell me what happened, what you want me to know about it.
I bought this car recently for someone else. I hadn't been driving it very much. I took off from my house to go to Ironton, and I noticed something to do with the vehicle that didn't seem right, like a wall, like the tire was, something wrong with the tire. So I pulled over at the Sheridan Fire Department, which is about a mile, I'd say, from where I lost the tire on the vehicle. So I went on down the road, and all of a sudden, the vehicle just felt like the tire locked up, and I spun out and went into the ditch. At that time, I got out of the vehicle, and there was a sheriff's deputy that was coming towards me. He seen it happen, and he asked me if everything was okay, that he was on his way to a call. And shortly after, the state trooper arrived and did some measurements and so on, and was speaking to me about the vehicle. And I noticed that he was talking to the tow truck driver, and he told me that I had a discussion with him that they had checked the tires and that they couldn't find anything wrong with it. I said, well, did they check the fourth tire? He said, no, they couldn't see it. I said, okay. So he said that he was going to write me a ticket. I said, you're going to write me a ticket on losing control when you can't check the fourth tire. He said, well, we can't see it. In order to do a thorough inspection of a vehicle, you have to check the entire vehicle, especially when the tire in question can't be seen. So I had tried to be thorough when I stopped to check the vehicle, and I couldn't see anything wrong. So I went on down the road, the tire came off, I spun out, there was nothing I could do, and I ended up in a ditch. At no time did I lose control of the vehicle. And I further went on to investigate, since I got a ticket for losing control and I knew that I hadn't done anything. So I looked it up on the internet. I went to 2 body shops, and they said that it's a common problem. They didn't want to fix it. I wasn't asking them to fix it. But they told me it was a common problem, that they see it. But I had no clue that that vehicle was like that, because I drive trucks, not cars. So all I can say that I did everything I could, and with the deputy coming straight towards me that I could see, there's not very logical for me to not be diligent in driving carefully in front of a police officer. That's what people do.
Mr. Hill, do you have questions?
No, I don't have any questions, Your Honor.
You may step down, Mr. Freeman.
Thank you.
Okay, I'm going to find you guilty, and the reason I'm going to find you guilty is that you had knowledge that there was a problem with the vehicle because it was to the extent that you actually stopped it a mile from the scene and got out and looked at it and checked it, and then still decided to proceed. So I think, I'm not even sure that even if it happened spontaneously, that would be an excuse, but in this case, you did have prior knowledge that there was a problem. So based on that, I'll impose a $50 fine and court costs. We'll need to see the clerk. Court's adjourned.
Thank you.
That's when you